floor. But right now, I want to take you to Parliament because the nominees for the Supreme Court are being vetted. Today we have Yoni Kulendi as well as Professor Henrietta Mensah-Bonsu, and you can see in your shot there Yoni Kulendi taking his seat. He just took his oath. We can now take you live to the Appointments Committee vetting.
Manuel has been missing for a while. It is resurfaced here today. On behalf of the committee, I congratulate you on your nomination to the highest court of the land, if this committee approves your nomination. Now, it is our practice that you will tell us about yourself briefly, and then we'll ask you questions trying to explore your knowledge of the law and your life. You may start, and please, I encourage you to be as brief as possible, because members here can also be very verbose, so try to be as brief as possible. Thank you.
Mr. Chairman, I'm most humbled and grateful to you for having me. Above all, I'm most grateful to God. Mr. Chairman, my name is Emmanuel Yoni Kulendi. The Emmanuel disappeared because I belong to this generation of Ghanaians who believed in going back to our roots and picking up our local names. So all my children born in England, none of them has an English name. I was born and bred in Wa in 1963. I hail from Issa, which is 32 miles northeast of Wa in the current DBI district of the Upper West region. I attended primary school in Wa, experimental primary. Mr. Chairman, the first time I crossed SAF, I must have been 17 years old when I crossed Bamboy. So I'm a made in Wa boy, through to Wa Middle Day School, Wa Secondary School. Mr. Chairman, if you have regard to my CV, you will see I indicate a period of 82 to 84, where in some very tragic circumstances, usually too traumatic for me to recount, and I hope that doesn't hijack these very important proceedings. I dropped out of school, resumed as a private student at Navrongo Secondary School, where I wrote GC ordinary level, went to New Job in 1985 to 87 for sixth form, where I met and married the beautiful woman behind me. I did my advanced level national service in Bolgatanga. I was adjutant to the CDO commander. I spent a year, 1988 to 89, in tech, squatting to do law, because I did not know that if you chose law as a second choice, there's no way they were going to admit you. I've chosen administration and law. Then I transferred to Legon from 1989 to 92, the Ghana School of Law, 92 to 94. Called to the bar October 94, and had the privilege of being a pupil of the prestigious law firm of Akufo-Addo, Prempeh & Co. Made an exit 96-97 to graduate school. The leadership of the firm were magnanimous to keep me as associate till I returned from graduate school in Monterey, California. I resumed my associateship at Akufo-Addo through to 2002, when I, by the grace of God, moved out to found the law firm Kulendi at Law, where I have been senior solicitor and managing partner. Currently, I have 30 lawyers on roll, and my life has been a life in the courts since my call. I have not practiced any other trade except things on the side. So, Mr. Chairman, that is basically the trajectory of my life in the last several years. I have done 26 years as a lawyer.
Chairman, let me thank you for the opportunity and to join you in congratulating the nominee, Yoni, as you are popularly and affectionately referred to. Through your CV, 1987, page 2, 1987 to 1988, adjunct to Regional Commander, Civil Defense Organization. So, did you have a bite of the Jerry Rawlings, we no go sit down, make the cheaters every day, as you were doing national service? Were you militia or you were just in a regional administration building?
Thank you, Mr. Chairman. I was adjutant to the Regional Commander of the Civil Defense Organization, a very conservative ex-soldier. So I had to quickly learn the ropes and the traditions in order to cope with the requirements of my job, because he had a military orientation, Mr. Chairman.
So probity and accountability and its consciousness, did you imbibe any value growing up?
Mr. Chairman, absolutely. I'm a consummate advocate of probity and accountability in all aspects of our endeavors.
You have indicated to this committee that all along you've been practicing law. I'll still come back to your CV. 1996, Naval Postgraduate School, California. What was your area of specialization for purpose of thesis and research? You want to share that with us?
Thank you, Mr. Chairman. Mr. Chairman, my master's degree is a political science subspecialization in international security and civil military relations. I studied at the National Security Affairs Faculty of the Naval Postgraduate College. The school is not open to the public. It's 98% military, 7 military officers, and persons of foreign service, State Department, intelligence orientation. But the circumstances of life presented me with an opportunity to pursue specialization in this regard, and I took advantage of it. My thesis was in international security cooperation, and my case study was ECOWAS. It's online, and it's an open document and accessible.
Now, if you understated ECOWAS, take the European Union as a symbol of continental unification. What about ECOWAS? Looking back at Africa, West Africa, what progress have we made or not made compared to the European Union?
Mr. Chairman, my study was not focused on the political and economic organization of ECOWAS. It was focused on security cooperation, sub-regional security cooperation, where the West African sub-regional example of the collaboration in ECOWAS in the Liberian intervention to restore peace. That said, as a student of political science and a conscious African, ECOWAS has been saddled with structural issues, primarily because of our Anglophone-Francophone divide. I know we have made some progress and we have hope of a single currency. I'm optimistic, but that we will realize that a single market is the way forward if we want to be able to play in the bigger global picture. But our challenges are many. And Mr. Chairman, yourselves as politicians perhaps appreciate this better than me, because several of you are members of various parliamentary regional subcommittees, even the ECOWAS Parliament, and you appreciate the complications in forging and taking sub-regional unity forward better than I can pretend to posit. Thank you.
The President has indicated to Parliament, subsequent to what this committee and Parliament does, you will be at the highest court, as Chairman alluded to. The Supreme Court of Ghana, as you know, exercises exclusive jurisdiction over interpretation of the Constitution. Now, in the Monica Lewinsky case in the U.S., one of the famous senators said that the rule of law, nothing less, nothing more, but all persons being subjected to the law. What's your view on the authoritarian pattern rule in law, and how will you use that to protect the rights and interests of all other persons under the law?
Thank you, Mr. Chairman. Mr. Chairman, all the authoritarian pattern rule, as you appreciate, is a fundamental rule of law that you do not convict or make a judgment on a man until you have heard his side of the story. It's what we say in common parlance, that you don't tie, for me who comes from the north, you don't tie a single tuber of yam. There always have to be two. So you must always hear the other side of the story before you reach a conclusion. This is fundamental to the essence of law. And any judicial determination that offends this rule is impugned in an irretrievable way and occasions a complete nullity. And both as a matter of common sense and as a person with a common law orientation, I believe that ought to be the case of any judicial determination properly so called.
Chairman, may I respectively refer the nominee to Article 131 of the 1992 Constitution to get his view on the right of appeal. And Chairman, with your indulgence, I read, an appeal shall lie from a judgment of the Court of Appeal to the Supreme Court. My interest in this matter is A, as of right in a civil or criminal cause or matter in respect of which an appeal has been brought to the Court of Appeal from a judgment of the High Court. What is your view? Should the words as of right necessarily be part of this constitutional provision?
Thank you, Mr. Chairman. Mr. Chairman, for now, that is the law, and there's a lot of sense and logic why in all matters, civil or criminal, citizen can be permitted a right of audience by way of appeal through to the apex court of the land. Mr. Chairman, after all, the Supreme Court is the final court. And so in matters where the citizen is minded so to do, the citizen should be able to access the highest court of the land. That said, from my experience as a practitioner, This outright door, as of right, to the Supreme Court, literally, in some cases, opens a floodgate into the court. And therefore, however frivolous a party's case may be, and however compelling a decision and reasoning of a trial court and an appellate court may be, the party can automatically access the highest court of the land. This has occasioned, if you want, a lot of traffic and jam in the Supreme Court. It's a right that citizens ought to have, but it is amenable to abuse. Is there therefore the need to consider some filtering of that automatic access? I don't know. I can just tell you the problems it occasions, the stampede, the frivolous flooding of the court with all manner of causes or matters that ordinarily, and given our understanding coming from a practice point of view of what practitioners are given to do, ways and means practitioners who will take any type of matter that will earn them money, stampede the Supreme Court with all manner of things, and you will find judges at pains to rid themselves and deal with all manner of appeals that ordinarily should not engage the time of justices in the highest court of the land. And I believe that is why in some jurisdictions, as in the U.S., the Supreme Court is not an appellate court as such, except in relation to a single door jurisdiction, constitutional matters. So, counsel, if you were given the responsibility to take out some of the provisions in the Constitution, would you consider this provision as a candidate to be taken out? Thank you, Mr. Chairman. Mr. Chairman, not in its entirety. I will consider or recommend some process, some filtering, in order that we can ward off frivolous and vexatious appeals. There is some filtering in relation to certain matters, but not in its entirety, because you are balancing the right of the citizen to have audience before the final and highest court of the land with the need to ensure and insulate the system from abuse by vexatious, frivolous, and mischievous litigants and lawyers. And in that balance, we have to be careful not to preclude people who may have very legitimate causes from being able to engage the wisdom of the wise men up there. Yes, Leader.
Thank you, Chair. Chair, may I respectively again refer the nominee to Article 14 of the 1992 Constitution and request that share your position, denial of bail in criminal trials. There seems to be a legal position on it, but my emphasis is on Article 14.3. When an accused person is arrested, the law provides that he shall be brought before a court within 48 hours. You know the practice. When the police wants to punish an innocent person so presumed by the Constitution, they do the arrest on Friday night. And then 48 hours. What will be your position in this matter to respect the rights and freedoms of those persons?
Mr. Chairman, thank you. I have, throughout my career, always had a very straightforward attitude to the terms of Article 14.3. I have always insisted in all my, and I'm notorious for it, within the police and security services, that 48 hours mean 48 hours. And I put up a fight of my life when it comes to this. I must say that I'm excited that in some recent matter, I believe that the courts have given elucidation to this provision and laid out in unambiguous terms that 48 hours mean 48 hours, and that security agencies, people with powers of arrest, must ensure that the citizen is arraigned before a court of competent jurisdiction, and failing that, you ought to admit them to bail. And I'm particularly excited about that because it puts an end to this abuse by law enforcement agencies.
Are you aware of any court put in place to do such a thing if the need arose on a Saturday or Sunday?
Mr. Chairman, I believe this decision is recent. You're not likely to have weekend courts, but there's a practical interpretation you can give to the ratio of that decision, which is that if you are required, for instance, as lawyers, if your case is adjourned to a particular day, and for any reason the court does not sit, or the day becomes a public holiday, or for reasons of COVID, there's a lockdown, the case in practice stands adjourned to the next day that the court opens. And so you will go to court that next day for the judge to give directions. Therefore, in the circumstances of Article 14.3 and the recent decision of the court, what it will mean is that if there's 48 hours landed on a Sunday or a Saturday and you are operating in my district where there's no court within the district, you must ensure, or even if there's a court, the court is not sitting on the weekend, it then becomes incumbent on the arresting officer to make sure that on the next available date that the court opens, you have to arraign the person and let a judge determine the propriety of keeping the person in custody or admitting the person to bail.
Counsel, what about admitting the person to bail immediately the 48th hour reaches and inviting him over to court the following day?
Mr. Chairman, absolutely. That will be the attitude and ultimately the culture of responsible law enforcement officers who recognize that they are law enforcement officers primarily because the law says so, and not because they are born differently from the rest of us. And therefore, they ought to show fidelity to the law to all practical intents and purposes.
Chairman, thank you. May I now refer you to Article 128 of the 1992 Constitution? The Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. 2, the Supreme Court shall be duly constituted for its work by not less than 5 Supreme Court justices, except as otherwise provided in Article 133 of this Constitution. Share with us the tendency for the President, who is the appointing authority under Article 144, to want to load and overload the Supreme Court. What will be your desired ceiling and your justification for it?
Mr. Chairman, I want to say up front that I am a proponent of an open ceiling to the Supreme Court. The reasons are as follows. 1, Mr. Chairman, if you look at the doors to our Supreme Court, unlike other courts that we like to compare ourselves with, the United States of America, which is the most popular comparison, is differently positioned. We have multiple doorways to the Supreme Court, largely unimpeded doorways. The U.S. Supreme Court exercises only one of such jurisdictions. Now, I believe that the framers of the Constitution, in their wisdom, wanted to permit some structural flexibility in the architecture of the court, having regard to an upper ceiling. The challenge you will have if you imposed an upper limit in a constitution that we all like to say is a living document, and must continue to respond to the aspirations of the Ghanaian people as set out in the Constitution itself. We're going to wake up where our population is double the population today. Are we going to be rooting for another amendment? Or we wake up to circumstances where, given the legal activism and acts of positive citizenship that is characterizing the Ghanaian populace. And Mr. Chairman, I see a lot of positive legal activists on this panel who stormed the court. You're going to wake up to a time where the court is stampeded with such volume of cases. What do? You hold the people at the door and come back to the court and say, we have this number of justices. It's not possible to have the relevant numbers and panels to empanel to deal with the cases. So that's the consideration for those who advocate an upper ceiling. Number two, we have a different cultural mix, where, unlike in other cultural and social settings...
So, Chairman, to the nominee, what is your desired ceiling?
From the open, that I'm an advocate of an open limit, because a constitution must allow flexibility, it must be forward-looking, it must have structure that enables it to respond to the needs of the people at various points in time as the circumstances of society change. And to have a ceiling is to box yourself.
Chairman, that's appreciated. May I now lead you to Article 127 of the Constitution? And with the Chairman's indulgence, I quote, "In the exercise of the judicial power of Ghana, the judiciary, in both its judicial and administrative functions, including financial administration, is subject only to this Constitution." But I know currently the judiciary is struggling for funds. Yesterday we were told that sometimes they have to look for fuel on credit. They don't have the money. They are looking for adjustment to their internal generated fund. What is your understanding of judicial independence relative to their financial administration?
Thank you, Mr. Chairman. Mr. Chairman, you know, to the extent that the African adage, he who pays the piper calls the tune, is concerned, you cannot be truly independent unless you can pay your own bills without recourse to others. To the extent that Article 127 is construed in a way that requires of the judiciary, which is supposed to be independent in ways including financial administration and subject only to the Constitution, to have to defer to the executive and to Parliament to get approval of their budget, of their allowances, of development, funding, and all of that. You don't need to be Socrates to know that it's problematic. Mr. Chairman, I see even a bigger problem in the constitutional structure itself, where in relation to Article 71, where having said that the judiciary ought to be independent financially in relation to all the matters set out in Article 127, you go to Article 71, and if you look at the agencies contemplated under Article 71 for the determination of their benefits, the judiciary and its officers are there. And the process by which remuneration, allowances, budget, etc. is approved or determined under Article 71 is not in the hands of the judiciary. And yet they are supposed to be financially independent. But they have to defer to the executive to make a determination as to the salaries, benefits, and allowances of judges and judicial officers. Mr. Chairman, I must add that my suspicion, and that's my personal suspicion, is that the framers may have thought that if you lumped judicial officers with the executive and yourselves, you are likely to look after yourselves financially, and therefore the judiciary and all those independent constitutional commissions captured under Article 71 will have the benefit of your generosity to themselves. The oversight in that is that you people are politicians, and so even where you are inclined to increase your benefits, you are conscious of your constituents and the good people of Ghana who have a judgment over your heads. Therefore, the wisdom in keeping yourselves impoverished in terms of your benefits under Article 71 ends up impoverishing the judiciary and judicial officers. So currently, I'm aware that there's a policy directive not to increase allowances of ministers and all of you in the foreseeable future. What that means is that the judiciary is trapped in that restriction, and yet 127 contemplates that they should be independent financially. So you give it to them in the left and you take it away from the right. So I believe that this is problematic. It ought to be looked into. If we are sincere to resourcing and bolstering the judiciary and putting the judiciary in a position that they can determine the budget, hire judges with competitive remuneration that can attract the best.
So are you attracted with the current remuneration where you are heading towards, given what you earn from private practice? Are you attracted?
Mr. Chairman, it's, first of all, if my motivation was financial, I will not be sitting before you this morning, because I am conscious that from where I'm transiting as a private practitioner to where I'm headed in this place of honor, I needed to take, in terms of domestic democracy, I had to have the endorsement of my wife behind me that she's willing to scale down and needed, yes, everything. Because you have to cut your coat according to the size of your cloth. So I am conscious that I'm volunteering into a place. And Mr. Chairman, on a serious note, it's the reason why the judiciary does not, and without meaning, and I'm going there, and I don't think lowly of myself, but at certain levels, it doesn't always attract the best. I know many young lawyers who would want to be judges, but when they think about how they're going to pay their children's school fees, how they'll pay their bills, how they'll foot their travel, it is...
Chairman, I should be yielding the floor to my colleagues, but just want to know from the nominee, do you have a judicial philosophy? And related to the Sassan ruling of SOA JSC in the Tufo versus Attorney General, what is your judicial philosophy?
Mr. Chairman, I think that these, and I respect these characterizations, but I consider them largely academic. So I'm a student of all of those philosophies and a slave to none of them. And the reason is because my sense of the law is that whether you are interpreting or applying or enforcing the law, judges must do it in a way that ultimately occasions an outcome that is reasonable, that is fair, that is just, that is conscionable, that is equitable, and that whatever your philosophical persuasion, if you deployed the tools of the law and legislation in a way that occasions an outcome that is unjust, that is unfair, that is unconscionable, that is inequitable and unreasonable, my personal philosophy is that the law has failed.
Okay. Rose of the
Thank you very much, Mr. Chairman, for the opportunity. Let me congratulate the honorable nominee for this opportunity to serve as Supreme Court Judge of our Republic. Mr. Chairman,
Thank you, Mr. Chairman.
From the CV of the nominee, 1995 to 2002, associate, Akufo-Addo, Prempeh and Co. legal practitioners and notaries public, which means the nominee has had some form of interactions dealing with the current president. The interaction with the president. Working with the president. The president, per the Constitution, has appointed him to the Supreme Court. I don't have issues with the appointment because certainly a Supreme Court judge will be appointed by a particular president in a particular term. But his association with the president, what will you do if a matter involving the president comes before you at the Supreme Court?
Thank you, Mr. Chairman. Mr. Chairman, I did not and do not only have an interaction with the president. As a matter of candor, I have a relationship with the current president. Mr. Chairman, but it is also to the same extent that I have relationships with several other politicians and presidents. In fact, I can say as a matter of candor that if the president did not nominate me and was not too busy with the considerations of his office, if I were nominated for some other job, he will most likely be my primary professional referee, and you would have seen his name on this CV. I want to put that on record as a matter of candor. Now, that said, my understanding of a judicial role is that judges take the judicial oath, which is captured in this Constitution. Now, if you look at the tenets of that oath, it's a sacred pledge to the Ghanaian people, to God, and to your conscience that you will do right by all manner of men who appear before you without fear, favor, or ill will, and that you will show fidelity to the Constitution, the law, and be true to your conscience in your role. Now, therefore, that has to be my matrix and the basis on which I proceed into this job. Now, having said that, there are other considerations in the discharge of a judicial role. They include, among others, any situation where an adjudicating officer takes the view that there is a real likelihood of bias, or in some instances, even the appearance of bias. The tenets of this have been laid in our law in the Bilson versus Apalu case, where our courts set out the standard and incomparable jurisdictions, and therefore, not just to do with the precedent, but Mr. Chairman, I see around this table people with whom I have some very extensive social relations and dealings. If, by the grace of God, you approve me for this job, and a matter comes before me that involves one or any of such persons, I will have to engage the considerations of my oath, the considerations of conflict of interest, the considerations of bias, and due fidelity to the law. And in saying so, let me put it on record that there are different types of courses of action. You can have political courses of action as distinct from personal courses of actions. So if you look at several of the cases in the Supreme Court that Ghanaians of an activist, constitutionally activist orientation, some of whom I say are sitting here, you will see, Mr. Chairman, cases standing in the name of the Honorable Okujato Ablakwa. But if you have regard to the case, it's not personal to him. It's an action he takes to vindicate the law and vindicate the Constitution. And therefore, even though he is married to my niece, I should be able to deal with that matter because it is not personal to him. On the other hand, if the same Honorable Okujato Ablakwa is involved in an investment dispute, a property dispute, a money dispute with another person, I will have to take into account the considerations of bias, ask myself, can I be fair-minded when I know that he's taking this money home to ensure that my niece doesn't come to me looking for help? In those circumstances, you will advise yourself accordingly. I have practiced, as I said before the courts, I don't take this business lightly. I think that judgeship is a sacred responsibility. And also, let me say this, Mr. Chairman, in all humility. The man who trained me knows me. And I like to say that I'm a Pepe man. And my cultural orientation and my personal value system is that if you ever deal with me in considerations of right and wrong, you may not like me. Because I tend to see black as black and see white as white. I am being socialized to see gray.
The original people who were called Pepe, which means fairness, Pepe, not all of them still exist.
Mr. Chairman is right, but I always have said this in defense of the values that there are today two categories of Pepe people, and that we have Pepe of the blood and of the soil. And you also have Pepe of the blood, but not of the soil. As I told you, before I crossed Bamboy, I was 17 years. So my core values were crystallized. So I'm a Pepe of the blood and of the soil.
Thank you, Mr. Chairman. Mr. Chairman, my second issue has to do with legal education in Ghana today. It's generated a lot of problems amongst students who want to go to the professional law school after the faculty program. There is a school of thought that believes that Ghana Law School must allow the faculties to undertake the professional courses so that the legal council come up with examination to qualify people to practice as lawyers in the country. What is your view on this matter?
Thank you, Mr. Chairman. Mr. Chairman, first of all, as I said, I was the only person to make it into Akufo-Addo as a pupil in my year. And it was just by providence, because I did not know him, he did not know me, I have no social relationship with him. He met me after an interaction, and somehow, he likes to say that he's a brilliant boy. I like to think it was the hand of God. Now, therefore, one of the things I have done is to have a practice that has an open door policy. And those who are lawyers here know that I have always had numbers, much to my detriment. It's impoverished me in many ways, but I believe that to whom much is given, much is expected, and that somebody gave me an opportunity, and so I must give others an opportunity. That's why I said currently our number in the firm is 30 lawyers, and of that 30, 8 or 10 of them, 8 or 10 of them must be pupils. So I'm involved a lot in post-law school, post-call legal training. For that reason also, I have been extensively involved in the internship program that has recently been instituted by the law school. So I'm very familiar with the problems having to do with legal education. Incidentally, Mr. Chairman, since I'm also on oath and I say I take this seriously, somehow I happen to be an examiner, even though the lawyers in my office do not even know. And all the noise you hear about examiners who pay themselves a lot of money and take their fees and fail them is not true in all cases, because I've performed that role over the years as a civic duty and I do not collect money for it. But I set questions and I mark questions. So I'm in that terrain and I've followed that conversation. I take the view that legal education needs structural reform. I believe so. You have a system that was designed 60 years ago that has not substantially been re-engineered. You're bound to have problems. Population have increased. Democracy and the rule of law has come to stay. You are legislators. Every legislator, if they can, want to be a lawyer so they can be more functional. Every member of the executive must have, in my view, a working knowledge of law. That means you need some level of legal education. When I used to be a private lawyer, I used to pray that you don't come and crowd the market for us. But you will need the law. Therefore, the appetite for studying the law is inevitable. In addition to population, in addition to numbers. Then in the last few years, accreditation is given to various universities to run faculties of law. In my time in '94, Legon was the only place you went to study law. You couldn't even study law in KNUST or in University of Cape Coast. So you entered the class, a class of 120, you went through baptism by fire. The first 40, there's a red line in order of merit. You do LLB. The next 22 red lines, you do law, BA. The rest of you exit the faculty. The 60 of you finish, and you do a straight transition to Makola. Now you have every university in Ghana, or most of them, with faculties of law and teaching law. And yet, you have maintained the same Makola, the same law school. You don't need to be a prophet or a magician to know that there will be a stampede at the door, and that wherever there's a stampede, there will be casualties. That's why we're having academic casualties in that journey. And then it's creating a crisis. So, do we need reform? Yes, we do. The reform must take into account the population increase, the appetite for the law, and also be brought in sync with the changes that are going on in other universities. I'm told that Professor Atuguba was convening before COVID a conference of academics, intellectuals, proficient practitioners, and judges to deliberate on the future of legal education. I think that we need to do a more comprehensive study of the problem, have a working group, let them make recommendations as to the type of reform that we need to align the demand with the supply. Otherwise, you just have a problem on your hands. And there are examples of other countries. If you want to be an accountant, you can go to any accredited school, but you go and write an exam, and if you pass, you're chartered. So is that an option? Yes, it's an option. Could we also, there are also other options. I don't want to prejudge the issue, except to say I agree with you, Mr. Chairman, that there ought to be reform. Reform has to be fundamental, but let's do it in an informed, structured, and well thought through manner, and not in a quick fix to appease the crisis of the moment, and then end up a few years down the road with an unsustainable system. Mr. Chairman, I'm grateful.
Thank you very much, Chairman. Mr. Chairman, some time ago, it was very difficult to get medical doctors to work in the rural areas. So they came up with certain policies to attract doctors to work in the rural areas. At the moment, we don't have enough lawyers, but the few that we have, they all want to work in Accra, Kumasi, Takoradi, at the expense of the rural communities. So if you go to Jaboso, for instance, you don't have a resident lawyer in Jaboso. So whenever there is a court, they have to come from Kumasi, and that delays. People have to struggle to even get access to legal services. That creates problems. What do you think as a practitioner? Ghana Bar Association, together with the Attorney General's office, should do to attract lawyers to such rural areas where we have district courts, circuit courts, where we don't have lawyers?
Thank you, Mr. Chairman. Mr. Chairman, it's not only some time ago that it was difficult to get doctors to rural areas. It's still difficult. I've been involved with trying to get doctors to my new rural district, and it's still fairly difficult to do so. But to the question, Mr. Chairman, you know, it's a fairly complex and difficult problem. Now, if you look at all the process and the journey to becoming a lawyer, it is a fairly protracted, difficult, and expensive process. And so when individuals endure that process and they finish, unless the marketplace incentives are there, just like it is difficult for the Honorable Chief Justice to hire and post magistrates around the country as he would have wished, because the financial constraints that he has to deal with, the budgetary constraints, doesn't give him the financial space anticipated in Article 127 for him to do so. It's difficult to attract even the magistrates. So is it difficult? Think about a private lawyer, somebody who is going to his school, he's finished, he has all this ambition, he's seen the lawyers before him. We all tend to vacillate towards where the market is. And that is why local government, making sure that we can create activity, industries, business in all the locations, and create the market there. Will people who follow the market, they will follow the demand, because you don't want to go through that problem and become a village lawyer. But there's also a more complex dimension. And Mr. Chairman, if I may, and it relates to an experience that the Honorable Yeli Chure may be able to speak to, because at the time that I was called to the bar, he was my regional minister. I had attended the call dinner, and And at the call dinner, I met now President, and we had a conversation, and he offered me a job on that day and required of me, this was a call dinner, to start on Monday. So I was the first in my class to get a job and to start work on Monday. And thanks to him, within that same week, I was following him and carrying into the Supreme Court. Now, when that opportunity came, I was supposed to do national service with legal aid. Legal aid had been trying to set up an office in the Upper West region, which is my region I love to my heart. And they looked at my background and they assigned me to legal aid, Upper West region. And I had just had an opportunity to do my pupillage at Akufo-Addo, Prempeh & Co. by every standard, the law firm that every lawyer will want to train. So I got to legal aid. I went to speak to the chairman then, who was the director of the law school, of the legal aid board, the late Mr. Bimpombuta, and may he rest in peace. And he taught me, and so was extremely fan of me. And he thought that, wow, what an opportunity. But, you know, we've been trying to open this WA office. The only circumstances under which I can reassign you is if the region were to release you. So it fell on me. He says, talk to the regional minister. And I knew the regional minister, the honorable member sitting here. And we had had interaction even when he came to study the law and got appointed as minister. And he was in contemplation, should I go, should I not go? I had the privilege of having a private conversation with him. So I knew that, hey, we know each other. So I called him to try to persuade him to release me so that I could be assigned to Legal Aid Accra and I could do my national service at Akufo-Addo. I ran him the story. To date, I don't remember the answer he gave me because he wanted to have a legal aid lawyer. So I had to go see Kofi Potofi those days, who was Director Legal Aid. And this guy, you could be anything. You walk to him to change your national service postings. He will walk you out. But I went to see him and had an argument with him where I had to convince him that, listen, I am a homemade guy and I'd love to go back and serve my people. He says, listen, I want you to go back, go there, become a big man in no time. I said, sir, what kind of big man will I be if I walk out of law school, go to Upper West, become regional legal aid boss? What kind of legal aid would I be providing to the people when I haven't even learned the trade? Who will be my pupil master? Who will teach me? So I had to make a case to convince the Director of National Service that I believe that ultimately, medium to long term, is in the better interest of the people of the Upper West that I stay in Accra, get a good orientation and grasp of the law properly, become a better and a more effective lawyer, and I can impact that environment. I had an argument with him. He says, go, you will hear from me. When I left, his secretary followed me out and said, hey, young man, listen, this man, he'll change. Nobody has talked to him that he listens to the way he listened to you. So I think he'll change your service. Those are the combinations of providence that got me to stay at Akufo-Addo, do legal aid. You'll see in my CV in Accra. Now, I leave it to your judgment whether today I have been of a better impact to my region, to my district, to my people, to the totality of the North, than if I had gone the first year national service, regional legal aid boss. So it's also a more complex conversation.
Okay. Yes. Honorable Member for Laura.
Thank you very much, Mr. Chairman. Let me take this opportunity to congratulate the nominee, Mr. Emmanuel Yoni Kulendi. I think the people of Upper West are very proud of your exploits. We are not surprised that you've made it to the apex court of the land. We are not surprised. I would like to say that if there is anybody on this table who can give a testimony on your character, your competence, your attitude, your mentorship you've provided for many young people, particularly those of us from the Upper West region, I will be one of them. And so, Mr. Chairman, I'm not one of the referees, but I have a very deep social relations with this nominee, and for which reason, Mr. Chairman, I would like to make these few comments and say thank you very much for the opportunity.
Mr. Chairman, I'm flattered and humbled, and I'm grateful.
All right, from the majority.
Thank you very much, Mr. Chairman. And Mr. Chairman, I must say from the outset that I proceed on the basis that our standing orders does not preclude dear in-laws from asking questions. And I will place on record that this nomination gladdens the heart, and we are very, very elated about it, very proud of the achievements of Emmanuel Yoni Kulendi, a reputable lawyer by all standards, and a practitioner worthy of high praise. And it's not because of the linkage or the relationship, but it's the fact which must be acknowledged. Having said that, Mr. Chairman, I will begin from the CV of the distinguished nominee. I observe that, contrary to our format, the nominee leaves out positions held and conferences and capacity building programs. If you look at the template we provided, we will have wished that you provided us information in those two respects: the positions you have held in various capacities, and conferences and capacity building programs. I don't know if you averted your mind to the template, or if there's any particular reason why you left that information out.
Thank you, Mr. Chairman. I had regard to the template. What I sought to do was to sift what I thought would be most relevant to this committee. I battled with myself whether I should start by saying that, you know, I was president of the debating club, I was class prefect and school prefect, assistant school prefect, I was president of the Law Students Union. I was, you know, I thought that I'll be begging the issues, and that is why that information is missing.
Well, Mr. Chairman, we normally require that. It gives us a deeper understanding of the nominees who appear before us. But, I mean, some of us know you very well, and so that certainly is not fatal. If you can please come with me to page 2 of the CV.
Right.
The number of entries, particularly entry M, N, where you just indicate the courses, but you don't tell us what came out of it. Was it a certificate? Was it a diploma? Was it a degree? You have 1996 Ghana Stock Exchange courses on basic securities, advanced securities, and securities trading. In 1996, you have, again, Ghana Armed Forces Senior Staff College, Teshi, Accra, Civil Military Relations and International Security. It's not clear whether it's a master's degree, if it's a certificate, if it was diploma. Are you please able to help us with some further details?
Mr. Chairman, I must apologize profoundly for that. And the confession is that, I'm unfortunately not big on formalities and certificates. And to confess, the first time I went to Legon since I left Legon to seek my degree was to meet the requirements of this process. I hadn't done so before. Yes, the first time I went to, I couldn't even find my call certificate to the bar. So it's only Friday that I got an attestation from the General Legal Counsel to show I'm a lawyer. I'm unfortunately not big. I go to colleagues' offices and I see certificates decorated. If you walk into my office, I have nothing like that. I always believe that the sweet of the pudding is in the eating. And so I'm not very formal. And that is why you will see when I spoke to my judicial or legal philosophy, if I pass your test, I tend to be focused on substance. So I'm sorry, but the stock exchange course is normally, and I've done courses that I didn't even go to collect the certificate. I was seeking the knowledge, and once I get it, I move on. And so the stock exchange course is the Ghana Stock Exchange training program that they run, and there are people here who, it's a certificate course. And Mr. Chairman, if you ask me for the certificate, I don't know where it is. The Armed Forces Staff College program was a 2-week program, but there was a graduation and it was certificated. I honestly don't know where it is if I cannot find my bar certificate. The 96-97 Masters program, I got the certificate, arrived only on Friday by DHL from the school. And it's a degree, it's a master's degree. The World Bank training was a certificate. It was a long-distance program, but they issued certificates. I honestly couldn't find it. I didn't think it was relevant. Aspen is a fellowship.
Honorable Ablakwa and then the nominee, probably maybe we just say that he can relate to the clerk's office for further improvement to the CV, given the admission that he has made. So you may focus on other issues. Thank you.
Thank you very much, Leader. I take interest finally on the CV before I move to my substantive questions. That you indicate under community activities, the penultimate page, that you hold a number of directorships of limited liability companies and companies limited by guarantee. You do not provide any details. Do you foresee any possible conflict if nominated to the Supreme Court? Do you intend to hold on to these directorships if appointed?
Mr. Chairman, obviously no. I mean, it's not legally permissible to do so. But you don't throw your bad water away till you have good water.
Okay, thank you very much, Mr. Chairman. Mr. Chairman, I want to come to the substantive questions now. And I begin from the vexed issue of capital punishment as relates to Article 13(1) of the Constitution. And I have a copy of the Constitution Review Commission report here. The matter came up for considerable discussion at pages 639 all the way to pages 651. And the recommendations for constitutional change was strongly advocated by the eminent panel. They recommended, and I quote, "The Commission recommends the replacement of the death penalty with imprisonment for life without parole, a stiffer penalty than the current practice." I would like to know philosophically where you stand on the matter of capital punishment. Should we amend the Criminal Offences Act? Should we amend Article 13(1) of the Constitution? Amnesty International and other human rights advocates say that Ghana is lagging behind. We are now amongst very few countries who are keeping the death penalty on our statutes. Last time I checked, on the UN member nations, 106 have abolished the death penalty. Ghana continues to be amongst the minority nations now. Is it your view that the death penalty should stay, or it is time to abolish capital punishment in Ghana?
Mr. Chairman, you know, I personally, in terms of my value system and my faith, do not subscribe to the death penalty unless it behooves on me as a judge so to do because the law provides for it, but I do not think so. Also, from my experience and practice as a lawyer, it is legal trial processes that lead to the imposition of the death penalty in case of murder under the Criminal and Other Offences Act or for treason under the Constitution. Now, judges, courts, and their processes, however we endeavor, are things done by men, and men are fallible, and the processes we drive are fallible. I believe that life is sacred, and men should not make it their place to take life, and that we can punish, we can reform, we can correct, but given that it's a process that is prone to error, if you impose the death penalty and then you realize that the process is erred, it is irretrievable. And I think that legal processes should not lead to an outcome, even in the criminal process, that occasions a loss, damage, or injury that you cannot recover, however egregious or wrong the conclusion was. And we see it even in trials. There's a recent case, Doji, where he did prison time, literally lost his life, but ultimately the final court of the land found that it was the basis of his conviction were erroneous. Check the compensation he got, but at least he has his life to live again. If that guy had been executed, end of story. So I don't subscribe to it, even though currently is the state of the law. And I think that for purposes of reform, and also so we can belong to the Committee of Civilized Nations, where across the world it is agreed that, you know, this is just, it's the most extreme. I think it's a progressive recommendation for legislative change.
Mr. Chairman, I want us to delve further into the nominees' open ceiling philosophy, which you espoused earlier about a cap on the Supreme Court judges. Don't you think that it could be a recipe for disaster where there could be political abuse? And I recall the APRM report criticizing Ghana for the Afre appointment as an example. If you do not place a ceiling and high-profile political cases coming up, you do not think that if we are to adopt an open ceiling dispensation, it could lend itself to political abuse? Have you averted your mind to that possibility?
Thank you, Mr. Chairman. Mr. Chairman, I believe that the framers of the Constitution, in their wisdom, know that in the nature of humans, anytime humans have discretion, discretion can be abused. So my favorite provision in the Constitution is Article 296. There are actually some people who call me Article 296, because anytime I have to confront executive action, 296 is usually my recourse. Okay, because humans as we are given to abusing discretion. So if you have, for want of a better word, a bad president, and he has too much discretion, he will abuse it. But the flip side of it also is that you don't expect a man to dance and tie his legs. So it's a choice between the man dancing in an ugly, obscene way or disabling the man from dancing at all. Do you need to engineer structural flexibility into a living document? Because this is not a document that it is given to flippant amendments. And just to be candid with you, you will see that throughout the life of the Constitutional Review Committee, you didn't hear my voice. And the reason is because I could not convince myself that we have tested this document long enough to want to subject it to such a radical re-engineering. I thought that we needed to give it some more time. But ultimately, my view was that, hey, let those who want to reform it and bring it, and we'll practice it. So in constitutional making, you opt more for provisions that can accommodate future needs. So think about a situation where if you had a ceiling, and then you also have practical incidents, just like we have a practical situation where you have practical incidents where you have need for panels and for judges, because judges are either conflicted or judges had dealt with other aspects of the matter. And so this Chief Justice has to empanel another court, and he doesn't have the judges. What does he do? He comes back to go through a process of constitutional amendment to increase the number. So to fix the number is to make it mechanical and to limit it as if you know the future and the beginning from the end. And there have been practical situations where the court, the Chief Justice, was hamstrung in finding the requisite number of judges to deal with a particular matter or the other. You are elevating judges from the Court of Appeal. Those judges, if you permit them to go to the Supreme Court, when they go there, any case they have tried, whether they did it in the High Court or in the Court of Appeal, is a no-go for them if that case comes up. So they are out. Mr. Chairman, if you permitted me to go to the court, imagine the clients I have had and the cases I have done. All of those cases, most of them, if they are personal, are likely to be no-go areas for me. So you don't want to create structural inflexibility in a document that is meant to be living. I think it just offends the nature of the document itself. If you have a bad president or bad executive who abuses his discretion, and let's face it, you know, I think that by the time anybody gets to the Supreme Court, and watch it, the lack of ceiling is not also a lack of restriction or limitation. You will have to go back and look at the appointment process set out in the Constitution itself. It doesn't give you a ceiling, but one, to begin with, if you decide to send somebody to the Supreme Court, your first port of call is the Judicial Council. Why the Judicial Council? That is an enclave dominated by judges. They know their needs. They know if they want more or they want less. and you must take their advice into account. So it's not a free-for-all for a president. Then from that place, where do you go to? You go to the Council of State. And from the Council of State, Mr. Chairman, why am I here? Because your good selves can decide. Mr. Kulendi, thank you very much. You are a good lawyer, but go continue practicing your law. It's a filter system engineered into the structure of the Constitution, and it's against the abuse. So the president brings his, and remember that people who exercise political discretion, that's why in the wisdom of the framers of the Constitution, any president and all of yourselves will go back to ask the good people and seek a renewal of your mandate and check out if you govern badly or you're a bad MP, your people will punish you. So there is also a political price if you unduly abuse the discretions given to you. You may fool the people some of the time, but not all the time. So I believe in flexibility. I believe in allowing the Constitution to live. I believe in structuring your Constitution in such a way that it can respond to changing circumstances and needs without you having to go back frequently to go through the process of amendment. The American Constitution, small book, hasn't been amended, but they make the law, of course, part of the jurisprudence is different. The British, they don't even have a written constitution, but over time, so you will see that for all those who are proponents of a limit to the ceiling, what is their basis? They normally will go back and they tell you that, oh, the court has always been 15. How did the 15 come about? It means that without a ceiling, but from time to time, adding and subtracting, a practice will crystallize where for all the filters and the people, they come to understand that plus minus worst case scenario stresses we need at this point up to 15. A time will come they think they need up to 17. A time will come they may think they need up to 19. So how come we always talk about 15 Council, when there's never been a ceiling?
You've given too much of the answer. Yes. Please.
Yeah, thank you very much, Chairman. I now want to come to my pet matter of COVID-19 questions. I've made it a habit to always ask a question about the current pandemic, which has really brought us into uncharted waters, at least in our lifetime. And here I take issue with the Impositions of Restrictions Act 2020, Act 1012, which this House passed and empowered the President to impose a number of restrictions. And this is now law which can be applied even beyond COVID-19 in periods of emergency. If you avert your mind to the interpretation section, which defines essential services, you have here listed water supply services, electricity supply services, health and hospital services, sanitary services, air traffic and civil aviation control services, meteorological services, fire services, air transport services, supply and distribution of fuels, telecommunication services, and K, public and private commercial transport services. Conspicuously missing are legal services. During emergencies, we have found out even with the management of the pandemic that there were reports of human rights abuses, excesses of the police, the military, and all of that. People will need legal representation to enforce their rights, even in these periods of emergency. Will you say that this, leaving out the legal profession, the bar, legal services, in the context of the constitutional right of legal representation, will you consider this fatal? And what will be your elucidation on this particular legislation, Act 1012, which leaves out legal services as an essential service in the law?
Thank you, Mr. Chairman. Mr. Chairman, you can always approach legislation and interpretation, in my view, from a progressive approach or from a conservative approach. And so if you are given to insisting that everything must be in black and white, your concerns like that have a place, and there's a good reason to insist on them. My sense is that Parliament passed this law, and so it was in the contemplation of Parliament. I don't know what parliamentarians were thinking, but especially having regard to your opening statement, that where you take issue with a particular provision, that sends to me an indication of a contention. Now, so what that means is that if you could not avail yourself, if you, let's say hypothetically, you are unable to avail yourself of the lawmaking avenues and windows to achieve the kind of change that you are looking for, possible you may make a recourse to legal action, okay, to compel some kind of amendment of the law in order to accommodate what is an essential service. Now, if you did that, and I'm sitting here in consideration for appointment if I pass your test, Mr. Chairman, beyond the views I have expressed, I will be reluctant to volunteer an opinion and a specific view, because that, in my view, could potentially disable me if you permit me to become a judge and you brought up that matter. And I'm sitting on the panel. It will be open to your opponent to say that, but Mr. Kulendi, you have a view on this matter, which is matter of public record, which you expressed even before you saw the issues. And therefore, I take the view that by reason of your prior opinion and legal views on this matter, you have prejudged the issue. I don't think that you can objectively engage the issues for trial. So if Mr. Chairman will permit me, this is where I'll end my answer.
Mr. Chairman, my final question to the distinguished nominee. In my background checks on your practice ahead of this session, it emerged that you seem to have a very high attrition rate amongst your young interns and pupils in your chambers, and that a couple of years ago, virtually all your young lawyers resigned en masse. There was quite a rebellion, and they left your chambers. I noticed from your CV you have indicated as your third hobby youth coaching.
That's right.
It doesn't appear that development portrays your youth coaching abilities in glory. It doesn't appear that, from what I picked up from those who passed through your hands, that this hobby is one that you seem to be excelling in so far. What do you have to say about your leadership skills and this matter of high attrition, a rebellion in your chambers, and all of that? If you don't mind.
Mr. Chairman, I have no record of a rebellion in my practice. I can say for the record that from about the 5th year of the firm, I have always ranked in terms of numbers of lawyers among the top 3 in the country. Now, I just told you that of the lawyers that I signed in, 8 or so or more of them are pupils. Now, I have applicants on the waiting list. There are other people walking out of law school. If I kept all of those people, after their training, you don't have room to take in more people. So we consciously insist that you come in, you train, and then you are free to move on. I believe in choice. I am a rather liberal but very strict leader. I've told you I'm a Pepe man. So there are things that people will generally tolerate that I'm unfortunately unable to tolerate. Okay, and so if I deal with you for a malfeasance that there are others sitting around you who say, whoa, if Mr. Kulendi does this to Honorable Okujato, then mine will be worse. They advise themselves. So you will have house cleaning from time to time. I insist on very high standards. My partners in the firm are people who, Mrs. Opoku Amponsa, who is one of my partners who is in this room, joined the firm in her second year. She did her service at the Attorney General, joined the firm, and has been there 17 years today. The next person, Daniel Seguose, who I believe is in this room, is in his 8th or 9th year. He's been in the firm throughout. I have people who are there long term. I have people who leave. I don't have a problem. I think that comparatively, I pay...
Council, two things that stand out. Your leadership.
That's
so. How well are you as a leader?
Absolutely. I think, Mr. Chairman, in all humility, I can say I lead well. I have mentored people well. I have impacted a lot of lives.
Has there been a rebel in your chambers?
I have said that, Mr. Chairman, to begin with, that I have no record of a rebellion.
Thank you very much.
But I wanted to satisfy him on people will come in and go, but I'm not a political leader. Mr. Chairman, the Chief Justice is the immediate past chair of the disciplinary committee of the General Legal Council. You have no idea the things that lawyers do. I didn't come all this far to allow some young lawyer to come and mess me up. I won't take that.
So is it your view that the departure of the Dennis Jumo group was a normal departure? Is that your view for our record?
Okay, so Mr. Chairman, since he has mentioned a lawyer by name, and it puts my leadership on the table, I am compelled to put on record a matter that for the rest of time I would never have done so. Mr. Dennis Jumo did not resign from the firm. He was dismissed from the firm, for the record. But I restrained myself from issuing him a dismissal letter because I thought he's a young man and I must allow him room to correct himself and and have a life. I thought that I would injure him professionally if I signed the letter. But he was dismissed from the firm, for the record.
With the other members? With his other colleagues?
No, because I don't know which other colleagues, but I'll tell you something. After
Honorable, I think if you mention anybody's name, he will be forced to tell us, and the person is not here to respond. So I please discourage you from personalizing it. I think
and Mr. Chairman, unfortunately, he's caused me to do something that I have endeavored not to do because I don't believe in it.
Chairman, that's fair. I thank you for the opportunity.
Mr. Chairman, I'll increase his akunta dues.
Have mercy.
It is not one-sided. It's both sides. You do against each other. Yes, Honorable Atacha.
Thank you, Mr. Chairman, and first Deputy Speaker of our Parliament. Mr. Chairman, I have a positive judicial confession to make, not to ask questions. I've worked with my brother, Yoni Kulendi, in a distinguished Akufo-Addo Prepare & Co. And I can say, with all they understand me, as a lawyer of immense depth and gravitas, a lawyer of industry, and one other side, a workaholic. So I'll tell my brother, just go to the Supreme Court and make a mark. Your tenure, if we permit you, is 13 good years. You have a golden opportunity that the generations yet unborn will read your decisions with joy. And if you are holding a walking stick, people wish that you came back to the bench to deliver seminal decisions. So I can only wish you well, and I don't have questions for you. Thank you, Mr. Chairman.
Mr. Chairman, I'm flattered and humbled. Thank you.
Yes, honourable member for Boko Central.
Thank you very much, Chairman, and let me join colleagues to congratulate Mr. Yoni Kulendi for the nomination to the Supreme Court. Let me start from what you just said in refusing to answer questions relating to the Imposition of Restrictions Act, in which you raised the question of whether there's a possibility that a matter may ultimately come to the Supreme Court, and you are there, whether this appointments committee can seek your opinion before you get to the Supreme Court, as part of the process of vetting and approving you. So, generally, in your opinion, the structure, you spoke earlier very impressively about the constitutional structure. Structure of appointing a Supreme Court judge is for the person to be nominated by the President to Parliament, for Parliament to vet the person. The process in Parliament is not strictly a legal process. It is political, it is everything that we do here. Okay. Now, so, how can you tell us that you won't answer questions that we ask?
No, Mr. Chairman, if that's the import, the honourable member, but that's not what I meant. In fact, I answered the question to an extent, but said that I will abstain from proffering a specific opinion. So I associated with the issues that he raised, but did say that you don't want to proffer a legal opinion or an advice. I appreciate, Mr. Chairman, that you are masters of your own procedure, and
I'm asking this because you are not the first first nominee to appear before us and refrain from answering questions. Even yesterday, at least I remember one nominee who refused to answer a question, and we've vetted other nominees who have declined answering questions, presumably believing that such a matter may appear before them. And the question is whether, because your position will be predictable, this committee cannot ask you and insist on that answer from you. So given what I see as your depth and knowledge of constitutional law, and having over the years observed the practice of this committee, can you, as a senior at the bar, can you help us, educate us, and tell us whether within the confines of the Constitution, even before somebody gets to the Supreme Court, whether a person can tell us, this committee, that he won't answer certain questions because he may set a view that may become predictable if the matter gets to him or her when the person gets to the Supreme Court. That limits our powers, and that's why I'm concerned. What's your advice on that?
Mr. Chairman.
Forget that you will go to the Supreme Court. Just speak as a lawyer.
Thank you, Mr. Chairman. Mr. Chairman, you will notice that I have spoken to legal matters and matters relating to the Constitution, and some very extensively. So to the extent that questions are not problem-specific, a nominee who declines to answer questions, if you go for a job interview and you don't answer questions, you are risking, you sure will not have the job. So if the questions are general in the way that they are formulated, you can get a flavor of a nominee's legal perspectives. But if you make the questions problem-specific, so let's say, for instance, if you nail a problem down to, say, covert, okay, and covert could lead to a constitutional conundrum and complication. And in the kind of population that we have, where will be the final stop? Is the Supreme Court. If you want me to give you answers, I can give you answers, but you will end up giving the Chief Justice an impotent judge if a problem arises and goes to the court. Then he will be constrained. And what betides you if you have a limit to your ceiling or you don't have the numbers to play with? So so you will have to use your discretion to formulate. If there are other ways you can test a person's appreciation of the law, then go to the problems that are specific. I will recommend that that's the way to go. But at the end of the day, as I said, you're the masters of your own procedure. You do. The courts have said to find the Attorney General, what you do here is not amenable to interrogation by any court.
Yeah. I don't know if you have watched proceedings in a place like the U.S., where a similar exercise is conducted to vet nominees to the Supreme Court. And I have seen situations where they actually pin to specific legal questions, their positions on gay rights, their positions on abortion, their positions on the relationship between the state and the federal government, specific legal questions. And is a Supreme Court judge not entitled to change his views on the law at any time?
The judge as well as the court may change his view. In fact, the Supreme Court is the only court that can do that. The point that I made is that if you proffer a legal opinion, a specific legal opinion in relation to a particular legal question, not in a judgment you are writing, but in a drinking bar or before a committee, and you are a judge, the matter comes and the litigant knows that you proffered this opinion. The litigant will tell you have an opinion. Now let's go to the U.S. In the U.S., when cases are pending in the courts, they debate and discuss the case and pass judgment on TV and radio and analyze it and say what the judges will do and what they will not do. We don't do that here. We have a hybrid. The U.S. system is different. If a judge is going to the U.S. Supreme Court, they actually want to know where you belong on all the partisan values, issues, etc., etc. That we didn't make that choice. Okay, and we didn't make that choice, and that is the reason why I had to deal with a question from the Honorable Ahi, what I will do in a court given my association with the president who nominated me. You know, it's because in our constitutional context, partisanship is not permissible at all.
You are being nominated to the Supreme Court to interpret our Constitution and develop the jurisprudence of the Constitution. if you appear before us, what better mechanism for testing your competence to go there than to ask you legal questions so that in answering and analyzing them, we'll be able to test your competence as somebody who can go to the Supreme Court?
Mr. Chairman, absolutely. And as your record will show, the minority leader took me through a constitutional law class, and there was not one question he posed and got that answer. But when you formulate a question and say, I have this issue, issues arise in contention. So I say, if you have a contention and you solicit my view on that contention, and I articulate that view here, and this is public, all Ghana is watching me, then tomorrow you go to the Supreme Court and you permit me to be appointed to that court, and I sit on the panel, and your opponent has heard this, will your opponent be entitled to take the view that, Mr. Kulendi, this problem was posed to you and you postulated an answer, therefore you are already biased by reason of your prior opinion? So that's the question that I mean, and that's the reason. But if you are welcome, Mr. Chairman, to ask me any constitutional or legal question, and to the extent that I feel able, I will answer. And I think that I have demonstrated that this morning.
Yeah, and you don't think that the question whether or not a nominee to the Supreme Court appearing before the Appointments Committee should answer all legal questions posed to the person, whether that is a constitutional question?
Yeah. Honorable Member Fobo, I regulate if I think that he should answer any question, I will insist, even if he says no. But on the issue of offering an opinion specific matter which is likely to be adjudicated, I think that has been accepted norm before us. And so we should please leave him the space to answer in that respect. Please ask another question.
Yes, I actually try to push my senior because I know he's a very intelligent constitutional lawyer, and it's something that has been agitating my mind. So it's not, it's meant to help us have a second opinion about what we've been doing here. I was excited about your reference to Article 296. Your reference to Article 296 earlier on, yes, and how that is a key tool in managing executive excesses and etc. Can you elucidate on that?
Thank you. Article 296, if I have Mr. Chairman's permission. Provides as follows, that where in this Constitution or in any other law, discretionary power is vested in any person or authority, that discretionary power shall be deemed to imply a duty to be fair and candid. Now, the exercise of the discretionary power shall not be arbitrary, capricious, or biased, either by resentment, prejudice, or public personal dislike, and shall be in accordance with due process and of law. And where the person or authority is not a judge or other judicial officer, there shall be published by constitutional instrument or statutory instrument regulations that are not inconsistent with the provisions of this Constitution or that other law to govern the exercise of the discretionary power. Mr. Chairman, I love this article. For me is my resort, and I think that it is where the Ghanaian people find refuge given the nature of a democratic political architecture, which is that, the people are sovereign, but the power is invested in the executive, legislature, the judiciary, as trustees. And in all of those situations, huge discretion is vested in all of these agencies and persons. You need to have such a strict test that when you exercise discretionary power, you must imply a duty to be fair and to be candid. So you cannot exercise it in circumstances where you are being unfair, where you're being unjust, where you're not showing conduct, you are not being sincere. It says that where you exercise discretionary power, you shall not, and the framers of the Constitution use mandatory language, you shall not be arbitrary.
Just to help direct you, there are values that you must respect in the exercise of discretionary power, but there are also structural prerequisites. I want you to look at the structural principle, which is that if you are not a judicial,
that this is a community of saints. So the judiciary must be grappling with its fair share of the corruption that is endemic in our culture and growing. And if anybody had any doubts at all, the Anas Armiao, Anas Taga-I revelations, rather unfortunately, but very scandalizing and embarrassing, especially when you have regard even to the pettiness of the corruption. Then you are confused. Is this a total depravity of values, or is corruption of necessity? Because in some ways, if we do the corruption dialogue and why our society is so corrupt, there are very structural problems. Okay, that fertilize corruption. Society's own perception and our values, what we think of you members of parliament and public officers, and how your constituents will bombard and impede you, and you have your Article 71, if you want, not too big a salary to manage with. So the judiciary has its fair share of it, but there's a strict code of ethics. Judges, if you prove judicial corruption, I know various examples where judges are dealt with, dismissed, etc., etc. But if you were to ask me, do you know of judicial corruption as a fact? I'm unable to say so, because if you then ask me who that corrupt judge I know is, I'll be constrained.
But judicial corruption, as a legal practitioner, when they say judges are corrupt, doesn't that also assume that lawyers are corrupt, and that the parties in the case are corrupt, and that everybody around is corrupt? Because the judge cannot be corrupt in isolation. It takes the giver, it takes the lawyer, and what advice the lawyer has given to his client. So if Transparency International reports say there's judicial corruption, it just means the legal system is corrupted. What's your take on that?
Mr. Chairman, I mean, the question is to a large extent correct, because you cannot corrupt yourself. It takes somebody. There's always a giver and a receiver. There's always a quid pro quo. There's an exchange. And so corruption will always tend to involve multiple actors, ranging from lawyers to litigants to court officials, and in some rather unfortunate circumstances, even judges.
Lastly, directive principle of state policy. My last question. Last question. I beg you. Last question, Chairman. I beg you.
Honorable Titus Glover, before we are
Most grateful, Mr. Chairman. I will associate myself to my colleagues to congratulate my brother, Mr. Emmanuel Yoni Kulendi, a very successful private legal practitioner with a lot of experience. And I have no doubt at all that your elevation to the Supreme Court will contribute immensely in administration of justice to our people. So once again, my brother, congratulations. I have just two questions for him, Mr. Chairman. My first question is that the Supreme Court that is being assigned to, where he's been given an adjudicating seat, is said to have 7 streams of jurisdictions. First of all, I want to know what they are, which of them are his special interests, and where do these jurisdictional definitions emanate from? First, what are they? Which of them are your specialty, and where does it emanate from? Thank you very much.
Thank you, Mr. Chairman. Mr. Chairman, I propose to answer the question in the reverse order. So first, the jurisdiction of the Supreme Court emanates from the 1992 Constitution, and it's set out in the relevant provisions. Do I have a preference? No, I do not, because if I have your nod, you will be duty-bound to engage all matters that come before the court that you may be assigned to. So you've got to have a mastery and competence in all of the various jurisdictional delimitations of the court. My Lord, what are these jurisdictions? The Supreme Court has original jurisdiction in all matters relating to the interpretation and enforcement of the Constitution. Then it has appellate jurisdiction, and its appellate jurisdiction is in respect of all matters, civil and criminal, that emanate from the lower courts. Now, in addition to that, as the apex court, the Supreme Court is also the ultimate supervisor, pursuant to its supervisory jurisdiction, of every other court. Now, as if this is not enough, now the same Supreme Court has some special, call them miscellaneous jurisdictions. Now, because it is the court seized with the interpretation of the Constitution. What it will mean is that any court that is seized of a matter that occasions a question of interpretation of the Constitution has to pause, because it's a peculiar exclusive preserve of the Supreme Court, and make a reference to the Supreme Court to interpret that matter, remit it back, the interpretation back to the court in which the interpretational issue arose, to resume the proceedings. Now, then, in addition to that, if persons who are ultimately determined to have been unlawfully unlawfully incarcerated and who do time in prison and they want to seek compensation for the loss of their freedom over the duration of the wrongful incarceration, your recourse is to the Supreme Court. In addition to that, all appeals that emanate from the National House of Chiefs go up to the Supreme Court. And so the Supreme Court, and that's what I have said, is in terms of our constitutional structure, different from the American Supreme Court that has the luxury of doing only interpretation and enforcement. Thank you.
Mr. Chairman, the famous Tufo and Attorney General is considered a watershed in the jurisprudence of this country. The Honorable Minority Leader, in one of his questions, wanted to know the nominee's philosophy on this matter. I want to digress a bit. I want us to share with us what are some of the salutary principles of the law that you can initiate on this very matter.
Thank you, Mr. Chairman. Mr. Chairman, Tufo and the Attorney General, among others, enunciates the underlying principle on separation of powers in governance between the executive, the legislature, and the judiciary. And in furtherance of that, it enunciates the principle which I alluded to, that what Parliament does here, proposed to do here, cannot be raised into question in any court of law. And so those in my recall are the two salient principles that came to fore in the Tufo and the Attorney General case, because it was the instance where the Chief Justice who had purported, and then more fundamentally, it actually also lays out or enunciates the principle of the supremacy of the Constitution. That was the primary point, and this is in relation to the objection that the then Chief Justice nominee, having submitted to Parliament, had by those prior acts been stopped from objecting to the consequences of submitting to the approval process of Parliament. The court held that to the extent that the Constitution or the law lays out, endorses the fact that he ought not to have submitted to Parliament in the first place, the Constitution will hold sway over anything that the individual does. And so that principle of supremacy of the Constitution and its provisions and of the law in general is laid out in that case as well.
Mr. Chairman, my final question, let me add this. Mr. Chairman, as a private legal practitioner, you had your own social life. And now that you have been elevated to the Supreme Court, how are you going to balance the two? Because as a member of the bench, I'm told you're a bit limited when it comes to social life. So how are you going to balance that? Thank you, Mr. Chairman.
Mr. Chairman, I am conscious of the solitary existence of their lordships, having regard to the fact that they lose some of the liberties that the rest of us take for granted, and that in electing to submit myself to this process, if you permit me, you recommend me for appointment, in some ways I will lose some of my freedoms. And Mr. Chairman, Mrs. Kulendi is very happy with that. But I must say for the record that it is not too much of a problem. I have, the nature of the work that I do as a lawyer has not given me much time to run around and play around. So those of you here who are my friends or I know will realize you don't see me anywhere because you are practically tied down in the work. So I guess to a very large extent, it will be a continuation of the life that I'm used to. Thank you.
Before I come to the leadership, I'll give the last one to Obiamwa, and then the leaders will take over. I will wait for them.
Thank you, Mr. Chairman. Congratulations, my good friend Yoni. Very soon I cannot call you Yoni, but my Lord Justice, Yoni. Congrats in advance. Yes, I'll start off with your pet area, 296C, which my good friend worked on. I don't know whether you are familiar with the famous Ransford France against the Electoral Commission, a case decided by the Supreme Court in 2012 on discretionary powers under 296C. Incidentally, our good friend Yoni was supposed to be a friend of the court, but ended up taking up the whole matter. In that particular case, the Electoral Commission had been sued for not publishing regulations governing the creation of constituencies before bringing the regulations to Parliament. The case was why the EC had not followed 296C to publish the basis on which they create constituencies before bringing the regulations to Parliament. I don't know whether you appreciate what I'm saying. The plaintiff was saying that the EC had brought regulations to Parliament for the creation of constituencies. The EC just submitted the regulations to Parliament and said the constituencies were 240. Now he had added, or the EC had added 35 to make it 275. 230, added 45 to make it 275. And that Parliament should pass it, as it were, once the CI goes through the 21 sitting days required under Article 11.7. The plaintiff said that this discretionary power by the EC should be governed by regulations, showing how did you come by creating these constituencies before bringing the regulations, listing just the constituencies for Parliament to approve. Now, my good friend sitting here said that if we were to follow strictly 296C, it will lead to a nuclear meltdown. Indeed, if I can quote him very well. But he said, such an expansive literal interpretation.
Honorable Deputy Minister, his words are just like yours.
No. I mean,
let's discuss the decision.
Yes, it was quoted by Professor Ateba. Professor Ateba just quoted those words. That it will lead to a nuclear meltdown.
Go down to Ateba.
That it will lead to grave mischief, and that it will be impractical for public officials and agencies in general to work. Now, the view amongst many people is either this judgment was too liberal and expansive, or this judgment has more or less disabled 296C, in the sense that every agency, when confronted with this matter, will resort to rounds for France against the Electoral Commission, and that should be the end of the matter. What would you say in the light of what I've said here?
Thank you, Mr. Chairman. Mr. Chairman, first of all, let me say that, I mean, what the Supreme Court lays is the law. And so my views or ideas or perspectives are just questions. But from my reading of 296C, my sense is that the regulations ought to be in place to lay the pathway as to how you propose to arrive at the number of constituencies, districts that you propose to create. Now, the reason is because 296, among others, is meant to midwife how you exercise discretionary power. To do the act and then legislate how you did it later is to put the cart before the horse. I mean, and it's a question I'm posing. I'm not propounding an answer. And I prefer to make it a question because, having said that, the law as enunciated by the Supreme Court is the law, and it can actually be, I'll be engaging in an unconstitutionality to suggest that the Supreme Court is wrong. That said, the Supreme Court is the only court that can change its decisions. And so I go back to my refuge, that take my question for an answer and don't force an opinion out of me in the event that if I pass your test, you add me to the judges that the chief panel will have the discretion to empanel. If this matter came up and I have a view on that question, then I will answer it more directly and in a far more relevant way.
Thank you. Yes, next question.
I'll take your answer, even though in private we can still discuss it. Let's go to Article 20 of the Constitution. Yesterday I posed this question to one of your colleagues. Article 20 talks about protection from deprivation of property. And the issue is about compulsory acquisition of property by the state, where the state is enjoined under Article 22 to make provision for prompt payment of fair and adequate compensation, and the right to access the High Court by any person who has interest or right over the property, etc., etc. In your practice, I'm sure you've come across such situations where the state will compulsorily acquire private property, and then for various reasons, either the state would have refused or neglected in paying compensation, and will still use the property and may even use it for other purposes than what initially it said it was acquiring that property for. Would you agree that it's become a problem in our legal system, and what would you suggest we do to, if for nothing at all, bring down such incidents?
Thank you, Mr. Chairman. Mr. Chairman, I mean, I must say that given the fundamental ownership of our land system, the state being a creature of law that came to meet the people did not come with land. So the state will always have to acquire land that has some allodial owner for public use and for all public purposes. Unfortunately, the use of the power of sovereign domain to acquire private lands and property has been characterized with very persistent situations where the state acquires land, enters into the land, uses the land, sometimes I agree with you in all manner of ways without dealing with the prior conditions set out in Article 21 that it has to be subject to the payment of prompt, adequate compensation and within a reasonable time. I do not exactly recall the case, but I believe that this situation occasioned, the persistence of this occasion, a case where the Supreme Court, I believe, has ruled that the state must pay compensation before they use the land. And I have to say for the record that I was involved in the Achimota School land case, where many years after the acquisition of what was family property, the families claimed that compensation was not paid. It had also to deal with aspects of the matter where over the years, because of the vast land that had been acquired and the obvious indication that Achimota School did not need all of that land, certain state actors proposed to use the land for other purposes, and so the allodial owners came back and re-entered the land. And so that you will see that all of the land from West Legon, Westlands, all the way to now touch the Achimota School fence is private development, but it's all state land and acquired by law. And so yes, it is a problem. Is the balance of reining in the state vis-a-vis the right to property of the citizen, and it's a challenge. And time without number, we have sat in that court and watched their lordships lament and sometimes lambast the Lands Commission for all manner of things. But I think that's how much I want to say for now. Thank you.
Yes, Mr. Chairman, the last one, Article 134, powers of a single justice of Supreme Court. Of course, in criminal matters, a single justice of the Supreme Court may exercise power vested in the Supreme Court in such manner as provided in the Constitution, and under civil matters 134B, the situation is provided. Looking at what has gone on since this Constitution was promulgated, and given the situation now, what do you think is the rationale for providing for a Supreme Court judge to sit as a single justice of the Supreme Court to exercise such powers about criminal matters and civil matters?
Thank you, Mr. Chairman. Mr. Chairman, the resort to Article 134 normally is in relation to interlocutory matters, and as you see on the clear terms of the provision, the single judge cannot deal with the final cause or matter. I guess it's out of expediency and to expedite proceedings and hopefully inure to a speedy and effective resolution of disputes. You don't want every ancillary interlocutory matter that arises in a case to engage the full attention of the full bench of the court. Just like the rules of Parliament allows yourselves as a committee to interrogate nominees, take a decision, and if you are unanimous, the House takes it and the business is done. It is only if there's no unanimity here that plenary will engage the whole exercise, which is a more extensive exercise, because in plenary there will be arguments and contentions and submissions, and it becomes a long process. It's a parallel to 134 in the court. So it allows the Chief Justice to select individual judges to deal with interlocutory matters as house cleaning, but you will see that the jurisdiction to deal with a substantive cause or matter is reserved for the court properly constituted. Even then, where the single justice deals with the matter and it occasions an outcome that the party is disgruntled with, the rules of court still allows the party to repeat the same matter before the full court, which is your plenary. Therefore, it's a very useful provision in the architecture, because it properly deployed, it will expedite proceedings and lead to a quick resolution of interlocutory matters.
All right, thank you. Now I'm coming to the leadership. They tend to be long, and by our practice, we indulge them. So I suggest that you restrict your answers to yes and no as much as possible. Otherwise, they'll take you far.
Very well, Mr. Chairman. Yeah. Thank you.
Thank you very much, Mr. Chairman. I think the advice is very useful. Well, I was going to say same to him. My brother, Yoni, congratulations.
Thank you, sir.
Your CV, I do not intend to waste much time, but just to point to you that a number of the items there, what I hold from page 3 to page 2 to 3, when you provide the dates, you don't give us the duration. So some you've done, some you've not. Some you just say 1996. I mean, it would be useful if it is within the year, maybe to give the duration, just as you've done in some other pages. But more seriously, if you look at the last page under community activities, I don't know what happened. Virtually the whole of that place, you did not provide the duration. So maybe you could get your officers to help locate the periods, and maybe you can finish us with those additions. Except to say, Mr. Chairman, the community activities, the D, earlier you were asked a question, and we're expecting that you are going to state the companies. I believe in answering, it escaped you. It is very, very important to us, because we need to put them as part of our records that before you proceeded to the Supreme Court, you were board of directors in these companies. And that helps not only us, but even yourself. So if you could provide those companies, it would be useful.
Thank you, Mr. Chairman. So do you mean I should name the companies right now?
If you can.
Very well. I mean, I obviously know a number of them. First of all, if I take limited liability companies, I believe I hold a directorship in Microcell Company Limited, and I know because I chair the board. And then I also hold a directorship and shares in a company called Jeddah Company Limited. Mr. Chairman, I risk missing some of the names, and I also must hold a directorship in Kulendi Academy, which is a school project, and companies limited by Garant, and then of course I hold a directorship in Kulendi at Law as well. Companies limited by guarantee, I hold a directorship and chair the Springboard Foundation. directorship in a company called Law Direct, and then I hold a directorship in it's an access to justice and legal education program I do with Professor Atefa. The name has eluded me, but I can do an inventory of them and submit it to the clerk if you permit me.
That's exactly what I was going to say.
I'm grateful.
I thought there were just about 4 or 5, but it looks like it's a long list. So if you do the inventory and submit, that will be more useful. Just find out any of the states companies or any agency board that you serve?
No, sir.
Okay, thank you very much. On that same page, where that's Jean, Mr. Chairman, where is the co-founder of Law Direct and NGO currently engaged in research towards the development of not-for-profit Citizen Advisory Center, Legal Aid and Legal Resource Center, etc. I just want to find out what is this about?
Mr. Chairman, by reason of orientation where I was trained, at Akufo-Addo, people just stream, and the boss then will throw the cases at us, and you did it with or without money, provided they came with problems. Mr. Akutampa is here. He was the leader of that kind of brigade. That fortune or misfortune has followed me into my current practice since I set up, and also by reason of my social origins. Everyone has a legal problem. They come to me. So I end up doing a huge pro bono. I run a very big pro bono practice. Most of the things that make some of you think I'm a rich lawyer, I did pro bono. And so along the line, I decided that why don't you try and institutionalize your pro bono practice separate from the commercial practice, because these young men my friend was talking about come and they think the business is about money, and I tell them I don't practice law for money. I practice law first as a ministry, and as they grow they get more aggressive about money, and I say you can live with your money tendencies and leave me alone where you met me. And I don't apologize for that, and I am likely to remain that way. So this Law Direct was to isolate it. I wanted to run the UK-type citizens advisory bureaus where people who have problems, legal problems, marital, family, maintenance, can just walk in, and I have lawyers I hire and put there who will give them that advice. Because when somebody has a legal problem, in my experience, it's like having a headache. People lose sleep, and just an explanation, advice will take the burden off them. They come in disturbed, they leave smiling because you've helped them understand it's not a problem. So that's what Law Direct is meant to do. The reason I say is in research is because I haven't been able to find the money to set up the office and put the lawyers there and isolate them. So we still do the pro bono within Kulendi at law. And so that's what Law Direct was meant to do. These things are my regrets if you allow me to go into this job, and these are the things I will not be able to do. That will be my regret.
Well, very interesting. I mean, I heard you say that you are not rich. But I don't think there's an impression out there, like you yourself rightly say. I say this because, I mean, usually when CVs are provided, a chairman will tell you, my practice here as a member of the appointment committee is to call every single referee and talk to them. And in your case, you have Justice Broby and then Nana Edu Jemfi as your referees. And one of them told me that his worry was that you were very successful, and he believed that you've made a lot of money and you are comfortable. Now that you are going to Supreme Court, he knew, which I saw you said in your very early submission, that you had to discuss that with the landlady to agree that she will scale down. So it was virtually like what he said, that you were a very successful person and financially very stable. Now you are telling us that we see you to be rich, but you are not.
Mr. Chairman, I like to say I'm blessed. Okay, I come from very poor, humble beginnings, and given where the grace of God has brought me and how far, I cannot, for the rest of me, say that I'm not blessed. I have more than enough. I mean, and the reason he would have said that, you know, so my partner, Mrs. Opoku Amponsa, who is here, has a term that we like to use. She says that we are reasonably comfortable.
I think that you know it's of the type of you and I, where even when you have 100, you portray as though you have 50. Not like the other way around, where they have 50, they show they have 1,000. And so we are always humble. And sometimes people at far, knowing that you are very stable, you are content, think that the contentment makes you rich. So I understand that. That's just by the on the lighter side. So, thank you. In your answer to a question about compensation that has to do with the Achimota School, will you admit the challenge that we have is not that the compensations have not been paid? Because, for example, where I come from, in the Asante region, every chief will tell you that, no, you don't pay for the land. You have only paid royalties. And sometimes, as maybe huge as those monies may be, you don't tend to get receipts. And 50 years down the line, 100 years down the line, a new family come and they say nothing was paid us. And sometimes it becomes difficult for you to be able to prove that something was paid because in after and receipts were not given. In practice, is it the kind of things that comes around more often in land litigation, or you think that is different when you talk about the compensation? I just want to get your thought on that.
Mr. Chairman, you're right. There are a variety of situations. There are those genuine situations where compensation may not have been paid. There are also those situations where compensation, even though it was paid years ago, landowners would collude with public servants, and then records cannot be traced, and they'll come back and mount claims. And courts and judges work with facts, the evidence, the law, and the arguments before them. And then the state, if the state actors and representatives are the people who condone the disappearance of the documents, then the state is at the mercy of these conspiracies. That's why I talked about occasions where you hear their lordships at their wits' end, frustrated and bombarding. So we need to have a national conversation about where we want to be as a people and whether we want to take this business of public trust seriously or want to allow corruption to fester till it swallows all of us.
Yeah, I mean, I perfectly agree with you. I mean, myself and the chairman, sometimes when we are on flight to South Africa, 6 hours, we could spend the whole time talking about some of this, our own attitude and dishonesty in public life and what have you. So I agree with you. Just, now I'm talking about the chairman of this committee. Just for curiosity, what is going to happen to your chambers after, if this committee approves to you? Have you thought about that?
Mr. Chairman, I have. As I said, I have 3 other partners in addition to me. These are all my juniors, talking about my leadership style. These are all my juniors who joined as pupils, who have stayed, done time, and been there long enough, and I've made them partners. Okay, and in very reasonable ways. So if I'm leaving, they will continue to run the firm. As I said, there are 30 of us. If I leave and the 29 of them cannot continue it, I've done my bit. I have decided that I'll take the cross of public service, and that's it. But I'm confident that they will do well.
Well, I mean, do you anticipate that you earn an emolument or fees or some monies from their service whilst you are a Supreme Court judge?
Yes, Mr. Chairman, I will. In the nature of the legal structure of the firm, I will. I guess these are private matters, but I'm obligated to say so. I will settle shares on them, but I will retain some shares because for the kind of work that we do, you'll be amazed that even though I paid the Social Security for every employee of mine, I don't have Social Security. By the time that the firm stabilized for me to pay my own Social Security, I was too old to contribute and meet the minimum contributions. So I have to depend on it's a very complex but interesting and fulfilling journey.
Chairman, this takes me exactly where I want to land. That our judges in our Constitution, in my view, I'm not a lawyer, sitting in this around this table over a decade and a half, clearly points to the fact that we do not have a clear-cut arrangement where they have to earn additional income, a lay-down procedure that they have to follow, like myself, like ministers of state, where in the Constitution and our rules, you have to come before Committee of Emolument, justify your business. Then if they believe that it will not be inconsistent and in contradiction with your work, Speaker authorizes it and gives you a certificate. I have taken that 4 times to be able to just retain my farm and other things that I do so that those incomes are properly known that I earn them. We don't have that with judges, because the last time this thing came up, so I seek permission from the Chief Justice, and then the Chief Justice granted it. In your view, do you think that we need to find a way of dealing with this in a proper manner, whether through regulation, if it requires even constitutional amendment? We need to take that boldly because it helps us to guide our judges in what they can do and what they cannot do in earning additional income.
Mr. Chairman, first of all, when it comes to judges, my sense of what judges do, what the law requires of them, and what society requires of judges. Judges should not have the need to go into the marketplace to do business or engage in other activity in order to supplement their income. If we want to take ourselves seriously, and that's why I say we need to have a national conversation, we need to take the terms of the Constitution relating to the financial independence of judges seriously, give judges the financial autonomy that they need. The Chief Justice should have enough money to be able to hire the best lawyers, and they should be induced to come to service. There are a lot of good lawyers who will not do this thing I am doing because they are not willing to compromise their standards of living and take this is not a shave, it's the cut of your head. That's what is going to happen to me.
It's very interesting to know that even at the Supreme Court level, you say they cut your head.
They cut your head.
Yes,
Mr. Chairman, let me make a confession to you.
For members of Parliament, we are at the level of the High Court, and yet they cut at our width.
Mr. Chairman, it's because he asked the question in relation to judges. But if
I'm just interested in the public view of what politicians are. It is totally wrong. Still, I saw a lecturer at the law school put out that MPs are paid twice the salary of Supreme Court judges. That's a lecturer of the law school. He published that. I couldn't help it. When I'm not paid even half the level of a Supreme Court judge, is there twice. But this is just, by the way, it's a comment.
So, Mr. Chairman, so my view is that we need as a people to have a conversation about how seriously we want to take the business of how we look after the people to whom we entrust decisions bordering on our collective well-being, our future, and the posterity of the country. If we don't take that business seriously, you're going to have human beings are human beings. You're going to have some people who are so wired that by their values, belief, and all of that, they will die poor than compromise. But those will not be the majority of the Ghanaian. The majority of the Ghanaian people, the people in my village are watching me. Some of them believe that this is an elevation to a bigger position of power and that I'll have more money. They don't know that levels will change and that I'm about to commit a financial suicide. So we should not, judges, we should not have the need to do any other business. We entrust them with making decisions on people, their rights, their freedom, their liberty, their business, their lives, wealth, their property. And you think that paupers and hungry men can do this business, then you have to find angels. And that's why we keep going back and forth about this corruption. And that argument can be extended to all those of you in positions of public trust. It's, if you pay bananas, you get monkeys, I'm sorry to say.
Well, I mean, I get your sentiments. I mean, I've had the opportunity to say, colleagues of mine that I'm not as old as you, even though I know it's not very far between us. Our colleagues who joined the military are already generals, and they are going to retire on their salary. Our colleagues who are on the bench, who completed school around the same time, who are on the bench, have gotten to a point where they also retire on their salary. But as a member of parliament, even after a decade and so, I go home, people just shout about ex-gratia, and they have no idea what it is. And I always tell people, look at former MPs, and don't look at those who did 1 term or 2 terms. Then look at those who even did 20 years before they left, and you understand what we are talking about. But that's for another conversation. What I'm saying is that whereas as members of parliament and ministers, if it becomes necessary like yours, where you already have established these chambers, now that you are moving, you still have to be earning from there. With the case of our judges, we have not made provision for them to be able to report it and get it recorded as we have done in the case of members of parliament and ministers of state. And that is where my question was. I'm not in any way trying to say you should find a solution to it, but your thought, how can we go around it to be able to provide that similar opportunity as we transition between where we are now, that impoverished virtual all of us who agree to do public service, and those who are in private, our colleagues in the private sector. What do you think should be happening to be able to get that properly done, so that you don't get people come here and sometimes you ask a question and it looks like you are trying to embarrass them? That's what I want to know.
Well, Mr. Chairman, my view is that in relation to judges, there's already a legal mechanism, because if you approve me before I take up office, I'll be required to declare my assets. And so if I have shares in Kulendi at law, I will have to make that disclosure in my asset declaration, because shares are assets, they are chattels. And if I have commercial interest shares in any other commercial undertaking, I will have to make those disclosures in my assets declaration. And the reason is just because of the very peculiar nature of what judges do. And I believe that in other jurisdictions, you have what they call a register of interests, where, say, prior to these proceedings, you will have a register of interests where any member who has some connection, deal, and interest will have to indicate that, so that when you make statements or you are making contributions, it can be properly contextualized that, listen, you are a shareholder in this entity. and etc., etc. I think that we need to be able to do that. But and Mr. Chairman, you will then feel more miserable if you found out what your colleague in the Bank of Ghana is earning,
sure,
or what your colleague is earning in Senate, who and other agencies of government who actually control public money. That's why I say we need to have a realistic dialogue, a national dialogue on where we want to go. Otherwise, the imams can say their sermons, the pastors can preach, but this demon called corruption will bring us down in the end. It
Thank
will
you.
get vulgar.
Chairman, I agree with you, but just have a deep talk as you proceed to the Supreme Court, because we equally declare our assets as members of Parliament and ministers. And if the businesses that I own, if I didn't declare them, then I have to relinquish them, or I'll be in breach of my, in addition to the asset declaration. But that's this, by the way. In an answer earlier to a question about the capping on the Supreme Court, you said the processes that leads to appointments are, in your view, vigorous and may inherently be a way of preventing abuse or restrain abuse. I mean, you mentioned the Judicial Council advice and the vetting in Parliament. I've been here since President Kufuor's time, and we've not had a hung Parliament. All the time, those in government have the majority. So if it has to do with Parliament, I'm sorry to say, even though I'm yet to remember whether once we have gotten splits over the nomination of a Supreme Court judge, my memory since President Kufuor's time, there have been this, we've not had that, where we have to go and vote over a Supreme Court and need to be corrected. But the advice, my interest is where the advice of the Judicial Council. It's an advice mandatory.
Thank you, Mr. Chairman. Mr. Chairman, first of all, I was going to say, first of all, an advice is an advice. But suffice to say that if you are in the legal community, I can tell you, and there are instances where the executive have sent proposals to the Judicial Council that they couldn't sell, even though the executive can have its way. Because we're a community and we know each other, if I had disciplinary issues, if I had ethical issues as a lawyer, if I were given to defrauding and overreaching my clients or my colleagues, the judges and even my colleagues and my peers will not, because we take our pride from the institutions that we want to think of a Supreme Court judge as a Supreme Court judge, and they are hallowed, it's a hallowed position, and we revere them. So they themselves, you have no idea. I mean, so there's a lot of, it works. The filters work. When it comes to you politicians, it's a different ball game. But in those areas, and sometimes there are also people that the Judicial Council may think that, listen, we should advise you to take A, but because anytime you have to deal with politicians, there's always some give and take and some negotiation. And it gets worse the more political the institution is. So, but the filter works. And if there are real issues, you will not pass, at least from my sense. I'm not saying nobody has ever passed, but it's a concern, because you don't want to send a judge who has no respect among his peers. Okay, and so if by the mercies of God you permitted me to go up there, it's a challenge. I'll have to demonstrate that I am up to it. But even before you arrive, we know each other, and we have impressions, and so it works. Everything human has its own imperfections, but I'm saying that it works, and just like all the structures we have built, our culture tends to compromise, undermine, slow, and do things, but if we are true to ourselves and will take our destiny and the common interest and the common good and our desire to build a good society seriously, this constitution, it's a good one.
Yeah, I mean, all your answers point to where there's goodwill. I mean, there's sincerity in actions. But we all know, there are several examples now in the history, many other countries, how dictators have emerged. And if you have an arrangement that is advisory, can you imagine if a president decides to ignore the advice, or maybe he sends names to the Judicial Council and he's not getting a response, he decides to write to Parliament for approval? Will you say that will be null and void? Because it's just advice you have to give.
Call Mr. Chairman to foresee how that will happen. You have to be a president who is possible, but
very well. And that is why, in my view, if we would rather put measures that will force us to build consensus. For example, if Parliament approval is supposed to be where you disagree by 2/3, you will naturally not want to go there, because you know it may be extremely difficult for you to get 2/3. So you always want to reach out, and maybe the advice turn into something more definitive. But obviously, that's for the law as you proceed, because it leads me to my next question. I mean, if you look at Article 184, where it talks about who qualifies to be a Supreme Court judge, and with that, maybe Chairman, let me just read, because it's not a very long clause 4. It says, a person shall not be qualified for appointment as the Justice of the Supreme Court unless he is of high moral character and proven integrity, and is of not less than 15 years standing as a lawyer. With the greatest respect, lawyer, you see that the only thing that you can really measure there is the 15 years. Do you agree with me?
No, Mr. Chairman. Mr. Chairman, as I alluded earlier, there are ways by which you can measure a person's character and their proven integrity. So take the nominee before you. I have been a lawyer for 26 years. If I have an inventory of ethical and disciplinary complaints against me, those are verifiable. If I have been sanctioned by the disciplinary committee of the General Legal Council, it will be verifiable. There are lawyers who have had their licenses suspended. There are lawyers who have been struck out of the bar, of the role of lawyers. There are lawyers, if I have corruption complaint, if I overreach clients, if I've done fraudulent things. So there are ways in which, and I believe that in the interrogations that some of you have done, that is how come the Honorable Okujato finds out that some disgruntled young man from my firm has talked about a mass resignation. You know, but it's because you weren't asking questions about me. So if I had gone around defrauding people, I'll not be of high moral character and proven integrity. Okay, if I had gone around, if you're a lawyer who takes, instead of your fees, you take services in kind for your fees. There are lawyers who have had those problems, and they've gone to the disciplinary committee and been sanctioned. If you Google the the disciplinary committee website, you'll be shocked at the kinds of things that lawyers are being sanctioned for. You swallow your clients' fees, you mismanage them if they go there. Of course, lawyers, because they tend to be in a position of power vis-a-vis clients, tend to abuse that, but the population is getting more and more functionally literate and more assertive, and a lot is changing. The time was when nobody sued a doctor. Today, we're suing doctors left, right, center, and people are stepping up and taking complaints against lawyers, and so the mystery is, and so my hope, after all the problems that we can dialogue about, is that it's a process, and I think that progressively we're getting there. Even though if you are my age, you tend to be in deliberate haste, and sometimes you're wondering, will I see this change that I desire for Ghana before I'm called to be with the Lord?
Well, I mean, whereas I agree with some of the most of the answers that you give, when you talk about morality, you know sometimes it varies from community to community. Let me say this: if you are a Catholic and you go for a second wife, they will see it to be very immoral, right? If a Catholic goes for a second wife, it will be seen as very immoral. But if a Muslim goes for a second wife, that is not, that's very permissible. So, and if someone, say, for example, is a judge, a known judge, because sometimes we see people who have risen from magistrate to what do you call it, the magistrate to circuit, to high court, to appeals court, and come here. And with the greater respect, they lie. Sometimes you can't even get people to serve as witness. But everybody who is listening to him knows that probably he even lied under oath. Will this not be a gravity? Because for Supreme Court, it's not like being a member of Parliament. It's not like being even a president. It's not like even being on the High Court or Appeals Court. For Supreme Court, we all have agreed by the framers of our Constitution to take the bar that high. Will you not agree that some of these things are very difficult to really put hand on, but our society agrees that these are frowned upon?
Mr. Chairman, I can agree with that, but, you know, if you are a Muslim and you are a polygamist or you're a traditionalist, our society understands that that's the practice and culture permitted by your faith. Now, if you are a Christian and you are a polygamist, that will be an immoral act. Now, whether you are Christian or Muslim, if you play with other girls around or sleep with your neighbors' wives, is immoral, and all of us as a society agree. So there are some subjective restricted layers, but we also as a people, as a common human species, there are certain things we frown at that we all think that this is improper, is unacceptable, and that for somebody who wants to enter into the higher office, you have to live like Caesar's wife, above reproach. If you're a judge and you go getting drunk and falling about in a drinking bar, or buying and not paying, and those things come up, they are procedures for dealing with you. Anything can happen to you up to losing your job. There are cases, where a judge, he is convicted, he comes back and sues for his benefits, and the judge says, no. You suffered this sanction, so you had ceased by reason of your incompetence on the basis of moral turpitude to be a judge. You are not entitled to the compensation.
Okay, so let's move, because I mean it's getting very interesting. You know, there's this adage. I mean, lawyers say it a lot: justice delayed is justice denied, right? And you believe in that too? Absolutely, but I read, and a lot of people believe that in our country, two things contribute to excessive delay. You are a lawyer, and because you practice, I just want to get your view on this. They believe appeals and the rules. inherently some of the reasons why in our country you have these excessive delays. Do you agree?
First of all, I don't. There are instances where appeals may clog up things, rules may. I think that we have structural problems. We have structural problems because we have communities that do not even have courts, access to justice. There are communities that even if you have a dilapidated court building, you can't find the judges to go and work there. You can't find the prosecutors. So the policemen just develop a predatory culture over the people because there are no forums to go to resolve the matter. The infrastructure is not there. There's a lot of congestion. There's not enough resources for training of support judicial staff. We mechanized. The object of mechanization was to do many things, expedite record keeping, because these are courts of record. So like you, everything that happens is recorded. So we introduce a mechanized system. But you have scopists who don't have the level of legal training that makes them appreciate and be very proficient with recording legal language. So in the end, you have the scopists who types, supposed to be fast recorded, but the poor judge must now go and read through everything. So you saved him the headache of writing, but you don't have the record of the court till the judge has proofread everything. So we need to invest in training, we need to invest in infrastructure, we need to invest in building courts, enabling the Chief Justice recruit and hire more magistrates, more circuit judges, even judicial training to lift their level of competence, because you sit in court as a lawyer. And one of the reasons why lawyers in Ghana are poor is because you have one case and you've been prosecuting the case for 3, 4, 5 years. You take the money that the client has paid, divide it, and the number of times you go to court. So the lawyer then tends to prey on the client. Every time you have to give money for him to go to court, every time he's using you. It gets to a point he will formulate processes he's going to file which do not exist and say, bring money so I'll file a process. But it's because the system is not, these things just build back, and that's why we are where we are. That's why I say we need to have a comprehensive conversation. What do we want to do to make sure our legislators can really work? What do we want to do to make sure that this special group of people, we say they're sacrosanct. We want them to deal with the issues, resolve disputes, and be impartial and give it their life. What must we do to position them to do that?
I just want to get your thoughts on prohibition of wearing of hijab, forced wearing of hijab, whether discriminatory and a breach of Article 17 or any part of Chapter 5 as a right. Because why I say forced to wear hijab, it is coming up very strongly, and I have the opportunity to speak very strongly against it, just as I've spoken for the wearing of hijab. Muslim schools now begin to force Christian girls who have been posted there to wear hijab against their will. You think this is not a matter as our country? We need to take it dispassionately, looking at our laws so that we deal with it once and for all.
Mr. Chairman, I think it's a matter that we need to take very seriously and to have some determination made in terms of the propriety of the regulations, the restrictions, or the impositions. I can say, and I'm fairly certain, that as we sit here, there is a suit pending before the Supreme Court. My brother, Dr. Bassett Bamba, is the lawyer who mounted that claim, and that matter is adjourned and pending. Just being practical and I believe in a disposition to accommodate and find a reasonable balance, I think that the last thing that would have happened was some direction to the parties to explore if they can find an accommodation, failing that the court will pronounce on the matter. Therefore, Beyond this, I cannot say anything because it's a matter pending before the Supreme Court, and I would not want to prejudge the issues.
Mr. Chairman, I may want to tell the nominee what is before the Supreme Court has to do with compulsory church attendance. Compulsory church attendance. That is what before the court. Wearing of hijab is not before the court.
Honorable member, you cannot say you know all the cases before the court. What is what you're referring to. He is referring to something else.
No, that's why when he mentioned Dr. Bassett, I've been involved in this since 2013, and in fact, we went to court in 2015. So it has to do with the compulsory church attendance. It has nothing to do with hijab.
Honorable, let me guide the witness and us by our rules. And Order 93.1 of our standing order says that reference shall not be made to any matter on which the judicial decision is pending in such a way as, in the opinion of Mr. Speaker, prejudice the interest of parties to the action. So, I don't know.
Mr. Chairman, I agree with you. And that's what I'm saying. If you hadn't mentioned the case that he's referring to, and just said that because he's going to Supreme Court and this may come, like yesterday Justice Tanko did, obviously I'll veer away. Because he made reference to what he says is before the Supreme Court, that's why I seek to correct that. What is before the Supreme Court has to do with compulsory church attendance in faith-based schools and not the wearing of hijab. That is what I want.
Very well, Mr. Chairman. I'm not in a position to dispute that because I do not have the record. But I did make an inquiry because, knowing what the contentions are, I anticipated that I'll be confronted with an issue such as this.
No, that's fine. I mean, if you are not comfortable to comment on it, that's fine.
Mr. Chairman, if you require me to, my view is this, okay? My view is that life is full of choices. And if you find out from the lawyers who worked with me, I insist that a lawyer must dress as a lawyer. Today is one rare occasion, even in spite of this heat, you haven't seen me in a three-piece suit. Because I say, I'm a lawyer, and this is how lawyers dress. Mr. Chairman, I believe that in this House, there's a dress protocol. You can't wear anything and come before this honorable House. What our policemen wear, it doesn't give comfort, but they chose to be policemen, so they must wear police uniform. I see the British police, and he's strapped with accoutrements, and he's not walking, he's crawling, and you see them running, and it's a pity. But he must carry all that gear on his body because he chose to be a cop and a bobby on the beat. So if you make the choice comes with consequences. Generally, I would say that you will have to live with that. So I cannot, if you permit me to become a Supreme Court judge, go to the court and say to the Chief Justice, I'm not comfortable wearing this awful headgear and looking like, something, or I don't like this because of the heat, and I have my views about the way lawyers dress, but you chose to be a lawyer. If you stop practicing law, chiefs dress in a certain way. There's protocol. Sometimes I see the chiefs and with all the things they strap, but you actually learn to dress that way if you don't know how to dress that way. So, generally, I think it borders on choice. Choice comes with consequences. And so when you make the election, you can't turn around and want to impose your peculiar distinction and preferences on the system that you have chose to join. So if you like to wear casual shorts, go look for a job on Florida Beach. Don't come and be an honorable member of the Parliament of Ghana because you insist on a formal attire. But on the beach, the formal attire is the swim pants, and you don't even have to wear a top. And if you're a woman, you can wear a strip. But you can't do that and come here, or do that and go to court. So, in general, these are my perspectives. How this will impact and bounce off on this Constitution, I will plead my cause that if you think you are going to approve me, spare me that
And then,
yeah, well, that's I agree with you. Like I said, that if you had chosen not to make comments, I would not force you to make comments. But your generality of is a choice. In Parliament, yes, we have choices. That's why we made our prescription of uniform to reflect the different society that we have. That's why you can see me always have my hat on. Others do not have. They have theirs, and we accept that because of the nature of the society that we find ourselves, there are different cultures and different beliefs. So we accommodated each other in the way we dress. Probably maybe in the, I don't know, maybe in other jurisdictions, they may just have a straight jacket thing. But in our country, we have our diversity in mind. And that's why we want to draw all of us attention that because of this diversity that we have, we find ourselves to be Ghanaians, and we have different cultures, different beliefs, different societies. We need to, at all times, accommodate each other. So I agree with you, but we all have to have, as we make this choice, because if it is just, I'm the boss now, I make the choice and decide what everybody wears. Tomorrow you will be, and you also are going to determine that. That may be different from mine, but if we agree, oh, we have your kind of group, you have my kind of group, we have this kind of group, our society will live forever in peace because we have accommodated each other. So that's just what I want to say. Lastly, in your view, how is law and order doing in Ghana?
Thank you, Mr. Chairman. You know, first of all, Mr. Chairman, I like to be optimistic, so I say we're doing well, but I also like to be realistic. There's a lot more to do. Our primary infrastructure for law and order is the civil police and the courts at the lowest level when there are infractions or breaches of the law. And we cannot pretend that we are all happy with the kind of police service that we have. You know,
maybe just to help you, are there areas of some concern?
Oh, absolutely, absolutely.
Maybe one or two that you want to share with us?
We need. There's our professional training has to be taken a lot more seriously. The culture of petty bribery and corruption, which undermines professionalism, has to go away. Discipline, you know, you have drunk policemen on duty. There's a whole there's an unaccountable use of people's power and our resources, and I think that we need. Because of my experience and my graduate work in security, I'm a big supporter of law enforcement, and you know that is why I have done some work for them in the past. But that said, we still need to up our game for country and people.
Thank you very much, leader. You said last and last and last.
No, I said I have one more to go. You are proceeding to the Supreme Court. And I just want to believe that since your nomination, you've also been thinking through where we are, as you are going, what you hope to do, and what you hope to get done. Is there one reform that you would like to see in the judiciary, and for what purpose?
Thank you, Mr. Chairman. As I have said repeatedly, I would like to see the type of reform that would enable the judiciary, add to infrastructure, add to training and support of training and building of capacity for support judicial staff, and even training of lawyers. You know, all the things that we need to make the judiciary be the judiciary that it ought to be. I don't relish a life for the duration that I'll be there in the kind that I have seen. And I'm hoping that this House will become more sensitized on the needs of the judiciary. And you know, you cut their budget by half. You ask them to keep 30% of internally generated money. Judges are hired, and almost a year into their employment, they don't have accommodation, they don't have a car, they don't even have a salary. And yet you expect these people to be this sacrosanct group of people. We need fundamental structural reform so that we can deliver the justice that the people of Ghana need. Because if the system, touch wood, does not function and the public lose confidence in the administration of justice, the alternative is not a future that we want for ourselves, or let alone for our children.
Mr. Chairman, thank you very much, and thank you very much for sharing your thoughts with us. We wish you well.
I'm grateful. Thank you.
All right. Ranking Member, Minority Leader.
Chairman, be assured with our colleagues that I do not intend to take too much time of the nominee. Having listened to our colleagues around the table, matters relating to his competence, his temperament, his experience and knowledge of the law have been brought to the fore. And it appears to me that he has no problem at all basking in acclaim as he represents what I may call a glittering bubble of legal success in Ghana, particularly from the Upper West region. But do you conceive of the Upper West region as a deprived, poverty-stricken region?
Mr. Chairman, definitely so. I mean, first of all, I think by the statistics, it is the poorest. Everything from income per capita, the poverty indices, schools, access to health facilities, everything. By every measure of development, the Upper West region lags behind.
And I hope that the young people and many people who are inspired by your elevation and certainly trust that you are accepting this nomination as a matter of public honor and not a matter of self-gratification in terms of motivation for money. The Ghanaian public naturally will have two concerns with your appointment to the highest court of the land. One is your strong personal bond with Nana Akufo-Addo Dankwa. That naturally should not be a problem, but an assurance to the Ghanaian people that when a matter is brought before court, you will conceive of it in this letter and spirit as a matter bordering on the President of the Republic and not your personal friend. Can we get that assurance from you?
Absolutely, Mr. Chairman, in no uncertain terms, and I believe the President expects that of me.
For instance, and he's human, like any of us. It's not every time that a president can get it right, but you know that the 1992 Constitution is one which is loaded with executive powers and executive influence. When the president writes to Parliament, for instance, that Article 241 of the Constitution be amended, or Article 243, you may want to go to it, and I just take you through it. There shall be a district chief executive for every district who shall be appointed by the president with the pre-approval of not less than 2/3 majority of members of the assembly present and voting at it. So the president comes to Parliament seeking to amend Article 2431 of the 1992 Constitution. And then conspicuously lost in the present correspondence to Parliament is reference to Clause 3, which says that the office of District Chief Executive shall become vacant when a vote of no confidence supported by the votes of not less than 2/3 of all the members of the District Assembly are passed. If such a matter was brought to you as the Constitutional Court, will you construe the instrument as a whole or part of it with your training in constitutional law? Share your principles with us.
Well, Mr. Chairman, from the training that I received from the President himself, by every standard, an eminent constitutional lawyer, this is the last document that you can read portions in isolation. You always have to read the Constitution as a whole.
Chairman, with your indulgence, my last constitutional issue, Article 252, I want to acknowledge that the Honorable Podo and Richard Kwashiga had cause to take this to the Supreme Court for an interpretation as to what constitutes total revenue by the definition of our Constitution. Now, if you have the court make a pronouncement on what constitutes total revenue, and you still have a Minister of Finance come to Parliament and not dedicate himself to every fine detail, what should happen as a legal cause of action to a person affected by this?
Mr. Chairman, I'm happy to profile a legal opinion since I'm still a lawyer and that's what I do for a living. But again, as I said, in the event it becomes a dispute, I believe that if the Supreme Court has spoken to a matter, that is the law. And every person, agency, or institution ought to respect, comply, and obey. And when there are duties incumbent on a public officer that the public officer does not neglect to perform or perform in the manner required, anyone interested in compelling performance has various tools under the law. You know, everything from mandamus to compel the performance of public duty or one imposed by law to a variety of other options. It depends on the choices that litigants make. Thank you.
Chairman, having regard to the death of the nominee in constitutional law and law generally, and noting that he has been candid to our committee, particularly the circumstances of his life between 1982 and 1984, that he regrettably regrets in recalling, and noting that there is no petition before our committee, I do not think that any country will want to deny a fine gentleman an opportunity of a talent to serve at the Supreme Court. I only can wish the nominee well. I thank you, Chair.
Mr. Chairman, I'm grateful. Thank you, sir, and thanks to the members.
Okay, the Chief Whip is over here. I have so many questions, but I'll ask only one. Now, you answered a question to the jurisdiction of the Supreme Court. You pointed to the Constitution. I'm sure to all the other courts, you can point to the Constitution or the Courts Act or to some other enactment. But in many judgments and in many pronouncements, the Supreme Court in particular, and maybe the Superior Court of Judicature, are used to saying the inherent jurisdiction of the court. Inherent jurisdiction. I don't see the Constitution mentioning that, and I have not seen where they inherited the inherence from. In your view, what is the basis for claiming that any court has any inherent jurisdiction to do anything?
Thank you, Mr. Chairman. Mr. Chairman, I'm just checking. I would have thought that there's a provision to that effect. But that said, just like humans have an essence, and inherent to being human is a right to dignity. So are institutions. This is Parliament. Parliament, as the representatives of the sovereign people of Ghana, in the nature of this institution, has certain inherent rights, privileges, prerogatives that even where they are not written, they are presumed. Now, if you constitute a court, in the exercise of the jurisdiction that is expressly conferred by statute, whether constitution or acts of parliament, if you're going to effectively perform those jurisdictions statutorily conferred, you will have to infer in the nature of a court a certain inherent jurisdiction that is innate to being a court. For instance, a court should have an inherent jurisdiction to protect itself from certain types of abuses. Okay, and then historically, given the jurisprudential tradition that we inherited, they are laid out in that jurisprudential traditions certain remits of this jurisdiction said to be inherent. And it is necessary and proper for the effective performance and discharge of the functions of a court. Just like there are rights that are inherent to being human, and if you took those away from a human being, there may be no difference between the human and an inanimate object or a table.
We'll continue the discussion further. Because
thank you, Mr. Chairman.
I think the jurisdictions of the common law countries were developed over the years, but ours started with the statute and the constitution. You know, so I wonder where we inherited our inherent jurisdiction from, but just an exercise of our minds. Before I discharge you, I have to acknowledge these eminent people who have joined us. From the judiciary, I have His Lordship Justice Eni Abuade, Chief Justice, who was here with us yesterday. He's here again today. His Lordship Justice Paul Bafuboni, Justice of the Supreme Court. My Lord Judge Samuel Boachi Adom, Deputy Judicial Secretary, okay. I've seen, I think, Justice Kote. Is there any others I can't see from here? Very well, so I'm done with the judiciary. I have also here Kuro Richard Babina Kuting, President of the Upper Regional House of Chiefs. Upper West Regional House of Chiefs, thank you. I have, a member of the Council of State as well. You're welcome. I have also Archbishop Nicholas Duncan Williams of the Action Chapel. There, I think. Very well. I have here also Dr. Hafiz bin Balib, the Upper West Regional Minister. Mrs. Gifty Afenyidazi, Prayer Director of the Women's Aglo, right? Lawyer Mrs. Amma Opokwamponsa. Okay. Lawyer Akutampa. Shish. Okay, I didn't say that. Mr. Kojun Penny.
And there's been over 4 hours of interesting drilling, but also elucidating vetting of the Supreme Court nominee, that's the renowned legal practitioner Yoni Kulendi, and of course he was vetted by the Appointments Committee following that nomination by the President, and that will be subject to approval of the entire House. Of course, regular programming continues from now until the next nominee, that is Professor Henrietta Mensah Bonsu, who is a law professor at the University of Ghana's School of Law. She will take her turn in the next few minutes, and we'll be live again in Parliament for that exercise. Please stay with us.